Yes,
Page
show me
60.
that. What is that allegation?
68.
Allegations are harassment and bullying at workplace. Indira Gandhi Institute of Child Health. Question is whether it attracts Commission's intervention. Bangalore,
Harassment in the workplace.
yes. Bangalore, Child Health Bangalore, Dr. Naveen Venkappa, Medical Superintendent, is against him, one. Removal from the post of unit head without assigning any reason, in spite of instructions of the Honorable Minister Medical Education.
Can it be decided by the commission?
No, I'll say it to you.
Yes.
Dr. Naveen Venkappa deliberately holding two posts of professor in pediatric and professor in neurology to deny me the opportunity of being promoted.
Yes, this is also no.
Deliberately false reports presented against me and recorded in proceedings of a GC meeting held on 27/7/2016
Yes.
to derail my future career prospects. It may come deliberately providing wrong information to MC regarding the number of units functioning in pediatric medicine department to avoid my promotion.
Yes.
Dr. Basuraj, GB, 10 years junior to me, made as unit head. Dr. Nijaguna, promoted to post of professor in pediatrics in spite of pending Lokayuta inquiry, though I was eligible for promotion. Dr. Kishore Padke, consultant in pediatric nephrology, Rainbow Children's Hospital, Bangalore, Bannerghatta Road, Bangalore, and visiting consultant pediatric nephrology, Indira Gandhi Institute of Child Health, and deliberately giving false complaint against me to harass and create obstruction to my functioning in pediatric nephrology. I had joined the Indira Gandhi Institute of Child Health in the year 1995. I have been working in the institution for the last 22 years.
No, that in that main subject itself, she has extracted. Which one is attracted according to you? All that is service condition, promotion is not given and all. Authority has to look into, not by the commission.
Yes. That may come as a different field and it may come to the court also.
Yes, they
But
cannot.
here, the other harassment which is caused to me, with respect to which Women Commission may look into.
Which is that you have to see. Then we can-
Particularly, she has not mentioned in the complaint, which are what harassment she is undergone.
Yes, that is that if that complaint is there in the particular issues, they will issue a notice. What is your answer and all?
Yes.
These are all that it is in related to that management.
Service
or-
conditions.
Yes.
Service
want
condition
that.
regulate.
If
regulated.
otherwise they have to do, because that commission power has been given to
The
safeguard.
power is, it has, commission is established by the government for a particular purpose to safeguard the interests of women in the working place, not necessarily sexual harassment, all kinds
No,
of
no, no.
harassments.
See, these are all that it is related to her promotion or her service conditions. That has to be looked into by that department in accordance with law.
Yes.
Either she is a male or a female, that is there.
Irrespective.
See, in that workplace, somebody is harassing her, other than that, then they can see that this is what that you are not taking care of that women's, they are harassing in that workplace and all. These are all you see that related to her service conditions.
Service conditions.
That they can't say that, no, given a promotion.
No, they cannot. I
that's
have not
what-
even sought for that.
That is
All
what
that
that,
I say, what is the harassment that I have complained of? Kindly look into.
no,
If
what
they
is that?
submit the report, so that on the report, I can proceed further.
No, I am asking that first you show me in the complaint,
Yes, my lord.
where is that, which, that commission act is applicable, then I can direct him to do it.
Then there is no purpose in giving the complaint at all to the
No,
commission.
no, you giving all complaint, they have to take, if there is an attracting the provision, then only, otherwise they have given a reply saying that yes, we have forwarded. Tomorrow, then we will go and give the complaint saying that I have not been given a
Well, my
promotion.
lord,
Is
I
it-
may say this way.
Hmm.
When is my complaint in 2016? They could have given me, well, it does not lie to us and therefore it is
But
returned to you.
now you are before the court. If you point out that this is that complaint which attracts that, then we'll ask them to.
Yes.
Yes.
When I lodged the complaint, he complained that I lodged the complaint with the Lokayukt. What the Lokayukt has said, well, we have no jurisdiction, approach.
No, even then, if they are not given any endorsement also, that doesn't mean that. But anyhow, you are before the court. You point out, I will ask them to replay
Yes.
that. Yes, when
My
you
lord,
want,
the
you go
complaint-
through that complaint and show me
For
that.
that, we have already sent a letter, my lords,
that
two
you-
letters.
You have placed,
I have placed
you place it by affidavit.
by affidavit.
Yes, leave this matter. After 2 weeks, yes. You place it by affidavit.
Lordship, can we fix the date?
Barley, 2 weeks. Let us see that. Let him file it in the, after.
No,
serving
very
the-
difficult to get it listed.
Yes, nothing will happen. There is no order stay against you.
Unnecessarily, Democles code is hanging over my head. She made reckless allegations,
I will see. that.
Allah,
it's not service conditions,
Sir, admits.
personal
allegations.
animosity, it's nothing but personal animosity.
Let us see.
She has become vindictive.
Yes, yes.
Serial number 34, Satish K.
Yes,
Lord, the petitioner is an employee of Lord.
who is your opponent? You are there. Ready?
Yes,
Yes.
Lord, the petitioner is an employee of
Hmm.
second respondent, the third respondent. Lord, page 64.
Employee of third respondent.
Yes, ma'am, third respondent.
Hmm.
Lord, on 13/5/2016,
Hmm.
annexure E, page 66. Lord, the petitioner has taken, my Lord, voluntary retirement.
Hmm.
Lord,
On 16?
it is,
Date-
he has
date-
tendered his resignation,
Hmm.
made a request to treat it as voluntary retirement.
Hmm.
Lord, on 13/5/2016,
Hmm.
my Lord, third respondent corporation
Hmm.
sought opinion from the Lord, government as to whether it can be treated as voluntary retirement.
Yes.
My lords will find the observation at page 67.
Where is your application?
Application I have not produced, my lord.
Hmm.
Page 67 is the opinion sought.
Yes.
ರಾಜೀನಾಮೆಯನ್ನ ಸ್ವಯಂ ನಿವೃತ್ತಿ ಎಂದು ಭಾವಿಸಿ ಇತರ ನೌಕರರಿಗೆ ಪಿಂಚಣಿ ಸೌಲಭ್ಯವನ್ನು ವಿಸ್ತರಿಸಿದಂತೆ ಇವರಿಗೂ ವಿಸ್ತರಿಸುವುದೆಂದು ಈ ಮೂಲಕ ವಿನಮ್ರವಾಗಿ ತಿಳಿಸಲಾಗಿದೆ. Corporation makes a recommendation to convert the resignation as my lord, voluntary retirement. Thereafter, my lord, the state government at annexure F, page 73,
Hmm.
asks the corporation whether it can be converted
Yes.
at page 73.
Yes.
Lord, the third respondent passes a resolution
Yes.
that similarly situated persons are given the benefit. It can be converted as, my lord, voluntary retirement. My lords will find the resolution at page 75, annexure G.
Hmm. Yes. Yes.
Serial number 3, my lord. Yes.
Hmm.
Then, my lord, it was forwarded to the government. Annexure H, page 77.
Yes.
Lord, similarly situated persons have been given the benefit at page 81, who were, my lord, given the resignation along with the petitioner.
Yes.
Page 81. That is, my lord, extract of the resolution.
No, that is that resolution passed by that, this thing.
Corporation, my lord.
Corporation is also given a same benefit to you also. It can be. Corporation has not denied.
Lord, yes, my lord. Then, my lord, these are the three persons: Shivarudrappa, Mamdapur, Shivkumar. They have been given the benefit. State has extended.
State has extended.
State has extended, my lord. Undisputed facts are, my lord.
Where is that state order?
Yes, state sort.
Because in respect of your case is also concerned, corporation is approved.
Yes,
Yes.
My lord, undisputed facts are, my lord, these persons are given the benefit.
Yes.
I'll show, my lord, I'll show. But then annexure K, page 82, recommendation is made. I approach this honorable court at page 85.
Now, what is that recommendation?
Again, my lord, they say that I am entitled for page 85, my lord. I approach this honorable court.
And
This honorable court dismissed my writ petition, which is at page 88, on the ground that, my lord, there is inordinate delay in approaching the court. Page 88, my lord.
Yes. Now, what is that relief you have sought?
I have sought for a direction to consider my case and implement the recommendation of the board,
Yes.
which is rejected. Writ petition was dismissed. Against that, my lord, writ appeal was preferred. But I'll read the observation of the division bench. My lords may I request my lords to kindly come to page 96, para 12. This has become final. The observation of division bench has become final.
The proposal to take further action of the sanction.
May I read, my lord? Para 12.
Pensionary benefit of the appellant, same shall be set within the period of 2 weeks from the date of the receipt of the copy
Yes,
of this
my
order. Yes.
Lord, the division bench allowed my writ appeal, directed, my lord, a positive direction is issued.
Where is that?
Yes, Lord, para 14, page 99.
Yes.
In these circumstances, we set aside the impugned order of the learned single judge, direct the respondent number 3 to forward the service particulars of the appellant, duly certified in terms of the communication dated 15/12/2017, issued by the second respondent, with the proposal for taking further action for sanction of pensionary benefits to the appellant. Sanction of pensionary benefits to the appellant. The same shall be sent within a period of 2 weeks from the date of receipt of certified copy of this judgment.
Yes.
Yes.
Para 15 also may be read, my lord, in that same judgment.
Nane odu.
Same judgment, para 15 may also be read, my lord.
Yes.
It is needless to.
It is needless to observe that on receipt of the said communication, respondent number 2 shall pass necessary orders in accordance with law within a period of 1 month thereafter. Appeal is allowed, disposed of. But it is needless to observe that on receipt of the said communication,
Yes. Yes.
but it is with reference to para 14.
Yes.
It cannot be read in isolation.
Yes.
There is at para 14, my lord, there is a direction to settle the pension.
Yes. Yes.
Then, my lord, the contempt was initiated. They did not comply with the order.
Endorsement has been issued.
No, my lord, the impugned order sits over the judgment of, my lord, division bench, which is at page 39. The only reason assigned is, my lord, page annexure A, page 39.
Yes.
Your lordship may kindly come to page 46.
Yes.
But the state admits that persons who are similarly situated are given the benefit. State says that in your case we cannot.
Why?
Page 45, my lord. This is the reason.
Yes.
It says that, my lord,
Which is the paragraph?
last 3 paragraphs.
Adesh ಕೋರಿ
ಉಲ್ಲೇಖ 13ರಲ್ಲಿ ಇಷ್ಟೇನೆ ಇದೆ. This is the reason.
Yes. ಉಲ್ಲೇಖ 13 ಕೋರಿರೋ ಅಂಶವಂತೆ
ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ಕೋರಿರುವ ಅಂಶಗಳಿಗೆ ಕೆಎಸ್ಐಸಿ ಸಂಸ್ಥೆಯಿಂದ ಸ್ಪಷ್ಟ ಮಾಹಿತಿ ಅಭಿಪ್ರಾಯ ನೀಡಿರುವುದು ಕಂಡು ಬರುವುದಿಲ್ಲ. ಅಂದರೆ ರಾಜೀನಾಮೆ ನೀಡಿದ 10-15 ವರ್ಷಗಳ ತರುವಾಯ ಪ್ರಸ್ತುತ ಸನ್ನಿವೇಶದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸ್ವಯಂ ನಿವೃತ್ತಿ ಎಂದು ಪರಿಗಣಿಸಲು ಸಾಧ್ಯವೇ ಎಂಬ ಬಗ್ಗೆ ಕೆಎಸ್ಐಸಿ ಸಂಸ್ಥೆಯಿಂದ ಯಾವುದೇ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. These are all communicated, my lord, long ago. Then, my lord, ಅಂತೆಯೇ ಸದರಿ ಅಧಿಕಾರಿಯ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸುವುದು ನಿಗಮವೇ ಆಗಿರುವುದರಿಂದ ನಿಗಮದ ನಿಯಮಗಳನ್ವಯ ಮತ್ತು ಕಾನೂನಿನ ಚೌಕಟ್ಟಿನೊಳಗೆ ಸದರಿಯವರ ರಾಜೀನಾಮೆಯನ್ನು ಸ್ವಯಂ ನಿವೃತ್ತಿ ಎಂದು ಪರಿಗಣಿಸಲು ಸಾಧ್ಯವೇ ಎಂದು ಕೆಎಸ್ಐಸಿ ಸಂಸ್ಥೆಯು ಎಲ್ಲಿಯೂ ಸ್ಪಷ್ಟೀಕರಿಸಿಲ್ಲ. ಬದಲಾಗಿ ಕೆಎಸ್ಐಸಿ ಸಂಸ್ಥೆಯವರು ಸದರಿ ಅಧಿಕಾರಿ ರಾಜೀನಾಮೆ ನೀಡಿದ ಸಂದರ್ಭವನ್ನು ಮಾತ್ರ ವಿವರಿಸುತ್ತಾರೆ ವಿನಃ ರಾಜೀನಾಮೆಯನ್ನು ಸ್ವಯಂ ನಿವೃತ್ತಿ ಎಂದು ಪರಿಗಣಿಸಲು ನಿಗಮದ ನಿಯಮದಲ್ಲಾಗಲಿ ಅಥವಾ ಕೆಸಿಎಸ್ಆರ್ ನಿಯಮದಲ್ಲಾಗಲಿ ಅವಕಾಶ ಕಲ್ಪಿಸಿರುವ ಬಗ್ಗೆ ಎಲ್ಲಿಯೂ ಸ್ಪಷ್ಟೀಕರಿಸಿರುವುದಿಲ್ಲ. Your lordship may kindly come back to, my lord, the recommendation of the resolution passed by the,
What is the law on that point? Can it be converted as a resignation as well a VRS?
but,
That is what the crucial point.
It's one the point, my lord.
Whatever may be
One of the
that
point.
directions.
Lord, the division bench has said, Lord, consider as a, Lord,
Therefore, they have added one more in accordance with law. Otherwise, they could have straight away said that consider in
Exactly.
within 3 months. If
Yeah.
it is accordance with law, then they have to verify that whether you are entitled under the law or
Lord,
not.
your lordship may kindly come to the observation of the division bench,
Yes.
whether they have any discretion to reject, but para 1296. That is the, my lord, short point, ma.
Yes.
The fact that appellant submitted his resignation and same was accepted on 30/12/1995 is not in dispute. There is also no dispute with regard to resolution so and so of the board of director of the respond number 3 held on so and so. On a perusal of the same, it is clear that respond number 3 decided to inform director of sericulture to communicate to the accountant general's office that the other 3 general managers, kindly note, though had also resigned from service, in respect of them, voluntary retirement had been considered for pensionary benefits, and on similar lines, the case of the appellant would also be considered. It is on those lines that a communication was issued by the respond number 3 to the respond number 2 on 2011-2017. It is in response to the said communication that respond number 2 issued a letter to the respond number 3 stating that in terms of the resolution of the board in 189th meeting as per resolution number so and so, the said decision of the board of the directors of the respond number 3 may be recorded in the service record, and after recording the necessary information, the proposal shall be sent for further action of sanction of pensionary benefits, and therefore service book was returned to the second respond number 3. In fact, by communication dated 2011-2017, the respond number 3 had intimated to respond number 2 about the decision taken in so and so, and the same was communicated, but the formalities had not been complied with by the respond number 3, in as much as there was no entry in the service record of the appellant, nor was there any formal proposal sent to the respond number 2 through the communication dated so and so. Hence, the respond number 3 did not act on the said communication and never took any step to record its decision in the service book of the appellant, nor did it forward any proposal for the second respondent. It is in this background the appellant filed the writ petition. Learned single judge has dismissed the writ petition on 2 grounds. Firstly, stating that appellant is not entitled for conversion as no document was placed to that effect, and secondly, there was a delay in nearly 2 decades in approaching the court since resignation was accepted on 30/12/19. We find that both the reasons are erroneous. Not kindly note, both the reasons are erroneous for the reason that annexure H and J are the very documents which are on record with regard to the decision taken by the respond number 3 in the matter of grant of pension to the appellant by considering his case as one voluntary retirement and not resignation simpliciter. Secondly, delay and latches could not have been counted from the date of resignation, which was 30/12/1995, as the decision on the request made by the appellant was taken only on 26/9/2017, and the same was processed. Communication was also sent on 2011-2017 and 15/12/2017, referred to the above respective authorities. No action was taken by the respond number 3. In the above background, the appellant was justified in seeking a writ of mandamus to the respondent number 3 to forward the service particulars to the respond number 2 to take a decision as per the board proceedings dated so and so for grant of pensionary benefits to the concerned appellant.
Where is that board proceedings?
I have produced, my lord. Page 81.
Yes.
Annexure J, page 81. May I read, my lord? After a detailed discussion, board felt that there is injustice done to Shri L.S. Balasundar by depriving the pension benefits when other 3 general managers who had submitted resignation similar to him but considered for pension benefits. Therefore, board decided to inform the Director of Sericulture to communicate to AG office that other 3 general managers, though had also resigned from their service instead of voluntary retirement, have been considered for pension benefits, and on similar lines, consider the case of LS
Mister, you have
Balasundar.
taken a positive decision. You have taken a positive decision saying that you are ready to send it back, send to that AG office for a pension.
Yes,
You are
sir.
not.
Then, my lord,
Therefore, division bench has taken that all 2 grounds which learned single judge has set aside and dismissed. I said that it is erroneous because management himself has taken a decision. Now that you are not challenging the finding of the division bench, now you can't say that, no, it is not in accordance with law. It is not in accordance with law, it's true. But on parity, you have taken a decision. Nobody has forced you to that. You have taken a decision that, yes, for this person also will grant. Now you can't say that I will not grant it.
My lord, this matter was came up before this honorable court several times, my lord. In one of the hearing, this Leonard government advocate produced the document to show that whatever given to those people are not in accordance with the law. They have issued a letter to withdraw. That I think that government advocate will come and tell, and that withdraw
ಮಾಡಿಲ್ಲ.
to withdrawing that, because that is withdrawn. That
Now, what is that withdrawn?
that pension benefits given to 2 persons cited by you.
Withdrawn.
That is withdrawn.
And you are not,
That is what,
But
that is the
it is,
question now.
my lord, it is not withdrawn.
all that, even that board, division bench has given that benefit only because similarly situated person has been given.
Yes.
So law is not,
Yes, exactly. That
this
is true,
thing.
my lord.
If it is withdrawn them, then we.
I may not have a case.
Yes.
Lord, last occasion, Lord, a submission was made that proposal is sent to withdraw. Lord, thereafter, Lord, there is no communication. As on today, it is not withdrawn.
On record, my lord. That is what information instructions, my lord. We'll place it on record.
Like you should have bring it when it is.
Yes, sir, my lord. That is the only issue, my lord, here. There is-
Yes, that is, if that is the case, then he has no.
Yes.
See, on law, he is not entitled.
Entitled, yes, ma'am.
But you have committed a mistake that has been accepted by the division bench. Now I can't say no unless
Yes, ma'am.
they have been withdrawn.
Yes, ma'am.
Lord, your lordship may kindly come to the reply. The state has produced the document to show that they are given the benefit.
No, now they are saying that.
Now-
withdrawn, realizing.
ಈಗ ಆಗಿದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ನೋಡ, the
Yes, at the request of government advocate, read this matter next week.
2 weeks, my lord.
Why?
ಅಲ್ಲ, Lord, the
Matter
petitioner is aged about, my lord, 86 years.
on
First-
2nd July.
2nd July, my lord.
Yes.
Please. Oblige, my lord.
Serial number 35, Tyagaraja S. Serial number
Yes.
35,
Yes, IA 1 of 2024 is allowed post this matter in B group.
serial number 36, Satish K.
I appear for the petitioner.
My lords, appear for the respondent in this matter.
Lord, question is, my lord,
Matter which has to be posted in B group. If there is an IA for early hearing and disposal, post it in B group. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ. With IA, post in the B group. Otherwise, no B group matter reach ಆಗಲ್ಲ. Yes.
Lord, annexure Q is the impugned order. Lord, by way of annexure Q, Lord, the old pension scheme is, my lord, rejected. Though we have made our request prior to the amendment, which is at page 167.
When you are appointed,
But we were appointed in the year 2005. But before that, my lord, we were working in some other corporation. Through proper channel, we have applied. Past services are entitled to be counted as per, my lord, regulation 182A of the, my lord, corporation. No, my lord, they have amended the, my lord, 182A itself with retrospective date. That may not be permissible. Lord, your lordship may kindly come to annexure A. Our appointment is dated 14/10/2005.
Next, yeah.
Yes.
Hmm.
Annexure A, my lord, page 34
Yes,
is the appointment orders.
yes.
Lord, annexure B, this is the appointment issued in, my lord, erstwhile corporation, not in the, my lord, KPTCL.
Earlier you were in where?
Karnataka Power Corp, confuse agate eradunu.
KPCL.
KPCL. Now we are employees of KPTCL.
Yes.
Lord, these are the appointment orders. Lord, through proper channel we have applied.
Yes.
Lord, the page annexure C, page 73.
Yes.
This is the appointment order issued in KPTCL.
Yes.
Lord, we annexure D is the, my lord, resignation, page 93.
Yes.
That is, my lord, my lords are aware, 252B. Service rendered in the erstwhile corporation will be treated as, my lord, technical resignation.
Yes.
Past service will be counted.
Yes.
Annexure D are the series.
Yes.
Then, my lord, the state annexure F, my lord, page 111. 182A, regulation 182A, my lord, is of the corporation.
11 page.
111.
Yes. Yes.
Wherever pensionable service under the board has been rendered in continuation of service in government, local body, so and so, the service rendered in such institutions shall count as qualifying service for pension subject to following conditions.
There is no dispute. They are not denying for a qualifying service.
Yes, my lord.
They are, now the question is that whether new pension scheme is applicable or old.
Lord, if the past service is counted, we are entitled for, my lord, old pension. Then, my lord, what they did, Lord, your lordship may kindly come to, Lord, annexure P, series at annexure, page 146.
Yes.
Page 146, my lord. They refer 182A, regulation 182A, and they say that, my lord, we are entitled, the proposal is sent
Yes.
to the corporation to count the past service and to bring us within old pension scheme.
Yes.
Your lordship may kindly note the date, 16/5/2017.
Yes.
Series of, my lord, resolution.
Yes.
Now, my lord, kindly come to annexure Q. This is the impugned resolution. My lord, regulation is repealed by a resolution. It is not a, my lord, amendment to regulation.
Yes. Yes.
The regulation is repealed with retrospective date, and all applications which are pending as on this day shall stand rejected is the, my lord, annexure Q.
Where is that 182A? You have shown that.
111 Swami, page 111.
Yes.
ಈ 182A ನೇ ಈಗ delete ಮಾಡ್ಬಿಟ್ರು.
Yes. Yes.
But kindly come to page 167. Solely on the ground that, my lord, it would burden the corporation. May I read, my lord?
Yes.
ನಿಗಮದ ಸೇವೆಗೆ ಸೇರುವ ಮುನ್ನ ಸರ್ಕಾರಿ ಸೇವೆ, ಸ್ಥಳೀಯ ಸಂಸ್ಥೆ, ಜಿಲ್ಲಾ ಬೋರ್ಡ್, ನಗರಸಭೆ, ಮೈಸೂರು, ಹೈದರಾಬಾದ್.
Already, see, employee service rules.
Please.
182 has been deleted by the director.
By, my lord, by a
letter.
resolution. By a resolution.
Yes.
Lord, 182A is the regulation, my lord.
Yes.
Director says that 182A is deleted.
Yes.
And, my lord, next 2. Your lordship may kindly come to 2 at page 168. ಕವಿ ಪ್ರ ನೀನಿ ನೌಕರರ ಸೇವಾ ನಿಯಮಗಳ ನಿಬಂಧನೆ 182 ರ ಅಡಿಯಲ್ಲಿ ಹಿಂದಿನ ಸೇವೆಯನ್ನ ಪಿಂಚಣಿ ಸೌಲಭ್ಯಕ್ಕೆ ಪರಿಗಣಿಸುವಂತೆ ಸಲ್ಲಿಸಿರುವ ಎಲ್ಲ ಬಾಕಿ ಇರುವ ಪ್ರಸ್ತಾವನೆಯನ್ನ ತಿರಸ್ಕರಿಸಲಾಗಿದೆ.
Mr. What is the procedure for amendment of that regulation?
Regulation.
My lords, we have filed statement of objections. I pray for date may be fixed, my lords.
After filing a statement of objection, what else remains, Mr.? Where is that power? Is it by resolution it can be deleted or any amendment to that regulation?
My lords, will convince my lordship, a date may be fixed, my lords.
Why it is posted today?
For orders.
Police issued.
Yes.
ಮತ್ತೆ ಯಾಕೆ IFR earlier?
But the reason is, but some of the petitioners are eager.
No, that is true. But IFR early hearing can be filed only if the rule is issued. Otherwise, IA will not be served. Yes, IA 1 of 2024 is disposed of. Is this matter in B group? When will you come back?
Next week, my lords.
Is this matter in B group on 30th? Yes.
This is the only short.
Yes, that's
My
the
lords, any other day after 30th. my lords.
Why? You said next week. Now you are saying that particular date. Yes, first.
Grateful, my lords.
Serial number 37, Nanjara DPL.
Prepare for the petitioner.
Appear for respondent 1 to 3. Raise them, my lords. We read to file our objections. 10 days time may be given.
IFR directions filed by that
Allah.
advocate for the
Of course,
petition.
sir.
What is that directions?
Direction, my lord, based on this certificate, that promotion should have been given in service candidates. So the post of,
Pertaining to the Open University matter.
Hmm.
The Honorable Supreme Court has also passed orders that he said degrees obtained by him are not valid. Produce the judgments, my lord. Your lordship may post it on Monday.
Yes, at the request of counsel for respondent. Is this matter on the 24th? Yes.
Serial number 38, Srinivasa K.
Lord, I appear for the petitioner.
Hmm.
This matter, my
This
lord.
application, my lord, has been filed by me.
Hmm.
Seeking for, my lord, the payment of the salary, my lord, on the principle of equal pay for equal work. Because the petitioners, my lord, are also discharging the permanent nature of work, my lord, since from the year 2000. And till date, my lord, they have been continued only as a temporary meter readers.
Lord, they
Not
said
that.
the reinstatement was done by interim order of this honorable court. Now, my lord, they are working. I'll have to file my
No,
objections
no,
on the.
there is no interim order here, sorry.
On the petition, my lord, I'll have to file my objections. Your lordship will post it 1 week time.
Second round of litigation, my lord.
Second round, I'll file my objections.
What is that IA you have filed, Mr.?
IA has
Start
asked
for-
for the present.
Equal pay for equal work principle ಮೇಲೆ ನಮಗೆ
What is
ಸಮಾನಾಂತರ
that endorsement you are challenging?
endorsement, my lord, is they have rejected my claim for regularization of my services on the ground that there is no provision of the regulations. And further, my lord, annexure yes may kindly be seen, my lord. is
Now
the-
that your service is continued,
I've been working, my lord, but
He's
only
working,
being
he
paid
wants-
13,000 rupees, my lord, which is, my lord,
but first you get it regularized, then you ask for full salary. Let us.
during the pendency of the writ petition, my lord, I have sought for the equal pay for equal work, my lord, that is the.
No,
Otherwise, your
see-
lordship may hear the matter.
Yes, that's what. No,
Next
matter
week,
has
my
to be
lord.
heard. Otherwise, if I directed them to pay that equal pay, equal salary,
It's
tomorrow
as
you
good
are,
as allowing is.
no, your writ petition is dismissed.
Yes,
Then you have not been regularized, but you have been asked to pay that.
my lord, I will be discharging the work, my lord.
Yes,
So-
we'll dispose of the matter itself.
Yes.
Yes, learned counsel for respondent number 2, praise finally week's time to file objection. Leave this matter on 2nd July. 2nd July.
Please,
we'll
please.
dispose of.
Great.
Why your regularization has been denied?
But on the ground that there is no provision under the regulations of the respondent corporation, one thing.
Minimum
And,
6 years services he had to.
We have worked, my
It
lord,
was a
for more than.
one-time settlement, 6 year service. If he has not put in 6 year service as on that date, my lord, he could not.
Then we'll see on records whether you have
Please.
completed 6. Yes.
Serial number 39, AD Ramananda.
I appear for the petition.
39, yes.
Your lordship, in this case, there is total irregularities in transfer. He is seeking for retirement. He may permitted to be retired. The earlier advocate on records is seeking for retirement.
Who is that?
Vaishali.
Yes.
For R3, my lords.
Memo for retirement filed by counsel appearing for the petitioner, Srimati Vaishali Hegde. Memo is taken on record. So and so learned counsel is permitted to retire from the case. Yes. Yes, Mr. What is that?
Your Lordship, in this case, there is total irregularities in the transfer. The first of all, Your Lordship.
My lords, I'm
I
appearing
would
for
like-
respondent
it is
number 2,
The
my
issue
lord.
is covered by the judgment. Let me make my submission. Let my learned friend have patience in this. Your Lordship, on 19/5, through WhatsApp, a message was sent to me that I am transferred. There is only 1 year, 1 month for me to retire. Very next day, I have approached this honorable court, and the very next day, the caveator has taken charge without me handing over the charge. And statutory restrictions are also there. Who are verge of retirement, they cannot be transferred. There is no accusation against me, and there is an ongoing exam schedule which was done by me during which is going to conclude on 20th. And yesterday, the relieving order is sent by backdated through post. So there is total irregularities.
Yes, Mr. Who is appearing for university?
My lords, I appear for the university. My lords.
My lords, I'm appearing for the respondent number 2, my lords, in the above matter, my lords.
The
My
respondent
lords,
number 4.
Yes. It's a case of transfer, Mr.
My lords,
It is
the
not
respondent-
that departmental inquiry that granting a time for filing a objection and all.
My lords, the respondent number
Otherwise-
4, my lords, has taken a charge. I am filing, my lords, the objection.
I will decide whether that notification of transfer is correct or not. If it is wrong, we will set aside and send it
There is,
to get it back.
it is covered by the judgment. I have given 3 judgments of this honorable court which squarely covers.
Yes. Give it.
My lord, I appear on
File
behalf of.
that, office.
Lords, all the pleadings are complete, my lords, the matter may be taken.
Yes,
Now
who
the
is-
new respondent number 4 has,
But you are the beneficiary. I want to know that who is that author of this order.
my lords,
my lords,
Passed by the-
the respondent number 2 is the author of the order, my lords.
Yes, you have to answer, Mr. Ready?
Please, my lords, yesterday only we have received wakalat, my lords, and we are filing today, my lords. In the counter, my lords, a week time may be granted, my lords. I will file the statement of objections, my lords.
Your Lordship,
Please, my
20th,
lord,
there is an
time-
ongoing exam. There is an
I'll
ongoing
file the
exam.
statement of
During the
objections,
exam, I have monitored the entire exam.
My lords, it's not a tenure
of-
post,
No,
my lord.
you take care of your service. You don't worry about that examination. They will take care of that. University will take care.
No, I am just bringing to your Lordship kind notice how.
It is not a tenure post,
There
my
is
lord.
some,
That will hear whether that transfer is in accordance with law or not.
Allah, your Lordship, there is a covered judgment on this issue.
Yes.
See, there
lord,
is
a
no
week
dispute
time, my
that I
lord,
have
so
1
that
year,
I
1
can
month
file
service.
objections, my lord. The
And there
numerous
is
complaints have been
statutory
received, my
restriction
lord.
also that
That,
for the men who are age above 55 years cannot be transferred.
Tuesday.
my lord,
Whether you file it or not, we'll decide on the.
Allah, your Lordship, it is
My lord,
covered by judgment. That is
on
what I thought.
Wednesday or Thursday, my lord. Wednesday or Thursday, my lord.
Yes. 24th.
My lords,
Yes.
Wednesday or Thursday, my lords. 25th or 26th, my lords.
No,
We'll file by that time, my lords.
25th.
Please, my-
25th.
no, your Lordship can have and
Please, my lord.
23rd itself, 25th, I have a date given matter.
My
It
lords,
can
then
be had on
26th, my
21st
lords,
because
if
Have
it
it
is.
26th.
26th.
Please, my lords.
26th. Yes.
Much obliged, my lord.
B group. B group.
Now, only thing, this is a very strange procedure which is taken place. There is nothing, WhatsApp message,
My
and
lords, it's
yesterday they
under
have sent a
the
relieving
Karnataka
order.
State Open University
See,
Act,
what
my
is the
lord.
law on that point? Whether they have any power to transfer you or the verge of retirement. That is your case.
No, there is statutory law itself there, 2 years,
My lords,
55 years
It's
they
under
can't
the
do.
Karnataka State Open University Act, my lords, where
No,
there is
either.
no.
Are you ready? If you are ready, you argue.
My lords,
Otherwise,
no,
yes,
my lords.
just-
I will file
yes,
statement of
yes,
objections, my lords.
Yes, B group.
No, your Lordship may kindly have it in the hearing stages because B group, if it is not reached, then the issue of, I have given the judgment which is.
Who said that it should be posted in B group? Mr. I said that call the B group matters.
Yes. Sorry, your Lordship.
Yes.
Preliminary hearing B group matter.
Obliged.
Number 40 adjourned. Serial number 41. Shashidhar Adiga.
Yes. Yes, Shashidhar.
Shashidhar Agali.
Yes, what is this, Mr.
My lord, R1 has to
file objections, my lord.
R2, my lord. This Legal Service Authority, my lord, has to answer, my lord. I have contacted the law department. They said that R2 has to answer. My lord.
Who is R2?
Legal Service Authority, my lord.
Who is appearing?
Mr. Vyasa Tirtha, my lord.
What is that? How it is legal service authority related?
In fact, they have
It
recommended,
is to promote the petitioner to the post of assistant category and grant arrears of the salary.
yes, my lord.
Matter, Mr.
Sorry, my lord.
What is this matter?
This is, my lord, we have joined for the seeking a promotional benefit, my lord. We have joined in 1980, my lord. But however, our services has been confirmed on 21/3/90. From 90 onwards, there is no promotion, my lord. And on 5th
No, last
October.
occasion matter was heard.
Yes, my lord. It was part heard. R1 was supposed to give reply.
No. I contacted the R1, my lord. They said R2 has to answer.
Our
department.
Where is that council for respondent number 2, Mr.?
Can
Where
you-
are you?
P. Vyasatirtha for R2.
Kindly pass on, my lord.
You
Yes,
ask
my
him
lord.
to
Kindly
come.
pass on, my lord.
Yes, you know that your colleague who is appearing for R2.
Yes, I know.
Are you informed him? We'll
Yes,
pass
my
it
lord.
on.
Kindly
Yeah.
pass on, my
Yes,
lord.
ma'am.
Kindly pass
Pass
on.
on.
Yes.
Serial number 42. Muralidhar KB.
Yes, Muralidhar.
Petition in this case, my lord.
Yes.
Lord, this is a case where, my lord, this honorable court was pleased to issue directions, my lord, on 11/6/2019 for payment of settlement of pensionary benefits of the petitioner. My lord, pursuant to that, my lord, on 21/3/2025, my lord, in the year 2019, my lord, his pensionary benefits were settled. Interest was not paid, my lord, but the interest now has been ordered to be ordered on 23/2025 along with the complaints affidavit filed by the government. But so far the amount has not been credited to the account of the deceased wife of the deceased pensioner.
Yes.
Lord,
So,
now if that amount is credited, my lord, this case can be closed, my
yes,
lord.
last occasion you have taken a
How
time, Mr. To verify that amount has been credited to that account.
This I'll verify.
The argument alagi, you have filed an affidavit before this court, said that amount is remitted. Now he said that, you see that compliance affidavit, Mr.
Kindly
Not
pass.
a one you file.
Kindly pass.
Compliance affidavit you have stated that we have remitted that amount. Last
Order
occasion you
ಮಾಡಿದ್ರೆ
said
remit ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಅದು ಎಷ್ಟು 1,85,676 ಅಷ್ಟೇ.
I'll verify. Kindly pass on.
No, you have taken time, Mr. Last occasion. To verify whether it is remitted or not, you are asking again time. Yes, pass over, Mr.
Please.
ಬರ್ಕಳ್ರಿ ಫೈಲ್ ಮೇಲೆ ಏನಂತ ಹೇಳ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ again, yes.
Serial number 42 pass over. Serial number 43 and 44 adjourned. Serial number 45. Shrikant MP.
The petitioner was appointed as multi-purpose rehabilitation worker. Being physically disabled, to work for those with disabilities. He is diagnosed with 50% disability. He was asked to not to attend the duties on the allegation that he has been dismissed from duties. The issue was considered by the Panchayat. Lordship may kindly have a look at page number 32, annexure F. It was on 5/12/2019.
Yes.
The Panchayat passed a resolution. Your Lordship may kindly see the last bottom portion. ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ಮಧುಗಿರಿ ತಾಲೂಕು ಪಂಚಾಯತಿಗೆ ಈ ಹಿಂದೆ ಜಿಲ್ಲಾ ಅಂಗವಿಕಲ ಇಲಾಖೆಯಿಂದ ನೇಮಕಗೊಂಡಿರುವ ಸೋನ್ಸೋ ಇವರನ್ನು ತಾಲೂಕು ಪಂಚಾಯತಿಯ ಆಡಳಿತ ಮಂಡಳಿ ಗಮನಕ್ಕೂ ಮತ್ತು MRW ಮತ್ತು VRW ಸಿಬ್ಬಂದಿ ನೇಮಕಾತಿ ಸಮಿತಿಯ ಗಮನಕ್ಕೂ ಬಾರದೆ ಏಕಾಏಕಿ ಕೆಲಸದಿಂದ ತೆಗೆದುಹಾಕುತ್ತಿರುವ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ವಿವರವಾಗಿ ಚರ್ಚಿಸಲಾಗಿದ್ದು, ಸದರಿ ನೌಕರ ಮೇಲೆ ಯಾವುದೇ ಗುರುತರವಾದ ಹಣಕಾಸಿನ ದುರುಪಯೋಗ ಕಂಡುಬಂದಿರುವುದರಿಂದ ಆದ್ದರಿಂದ ಶ್ರೀ ಸೋನ್ಸೋ ಇವರು ಬಡ ಕುಟುಂಬದವರಿದ್ದು ಹೆಂಡತಿಯು ಸಹ ಅಂಗವಿಕಲ ಇರುವುದು ಮುಂದಿನ ಜೀವನೋಪಾಯಕ್ಕೆ ತೊಂದರೆ ಆಗಬಾರದೆಂಬ ದೃಷ್ಟಿಯಿಂದ ಇವರನ್ನು MRW ಹುದ್ದೆ ತೆಗೆಯಬಾರದೆಂದು ಇವರನ್ನೇ ಸದರಿ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದಿರಿಸಿಕೊಂಡು ಹೋಗುವುದು ಸಭೆಯಲ್ಲಿ ಸರ್ವಾನುಮತದಿಂದ ಒಪ್ಪಿ ಅನುಮೋದಿಸಲಾಯಿತು ಅಂತ ಮಾಡಿದ್ರು.
ತೆಗೆದಾಕಿದೆ ಏನಕ್ಕೆ?
My lords, I would show. My lords, I was not even issued with not the order of termination. There was, my lords, representation made, my lords.
Is it only the state party?
My lord, the state only. My lords, may have a look at it, my lords. When I sought my lords information, they issued, my lords, annexure K and annexure L. Annexure L, my lords, said to have been passed. a copy which is not provided to me, page number 39 alli, that is what, my lord, the order of termination is.
Yes. Yes.
The first paragraph in preamble speaks of, my lord, some allegations being received against me. ಅದರಂತೆ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ದಿನಾಂಕ 31/10/19 ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳ ಮಧುಗಿರಿಯವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ತಾಲೂಕು ಮಟ್ಟದ ಗ್ರಾಮೀಣ ಪುನರ್ವಸತಿ ಕಾರ್ಯಕ್ರಮದ ಸಭೆಯಲ್ಲಿ ಸದರಿಯವರ ಮೇಲೆ ಸ್ವೀಕೃತವಾಗಿರುವ ದೂರುಗಳು ಅನಧಿಕೃತ ಗೈರು ಹಾಜರಿ, ಕರ್ತವ್ಯ ನಿರ್ಲಕ್ಷ್ಯತೆ, ಬೇಜವಾಬ್ದಾರಿತನ ಹಾಗೂ ಕರ್ತವ್ಯದ ಮೇಲೆ ಉದಾಸೀನತೆ ತೋರಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿಯವರನ್ನು ಹುದ್ದೆಯಿಂದ ವಜಾಗೊಳಿಸುವಂತೆ ಸರ್ಮಾನುಮತವನ್ನು ತೀರ್ಮಾನಿಸಲಾಗಿದ್ದು, ಈ ಸಂಬಂಧ ಸೋಣಸವರನ್ನು ಮಧುಗಿರಿ ತಾಲೂಕು ವಿದ್ಯಾಶ್ರಮ ಪುನರ್ವಸತಿ ಕಾರ್ಯಕರ್ತರ ಕರ್ತವ್ಯದಿಂದ 31/10/2019 ಅನ್ವಯವಾಗುವಂತೆ ವಜಾಗೊಳಿಸಿ ಈ ಕೆಳಕಂಡ ಆದೇಶ ಹೊರಡಿಸಿದೆ. ಪ್ರಶ್ನೆ ವಿವರಿಸಿರುವ ಸೋಣ ಕರ್ತವ್ಯ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸೋಣಸೋ ಇವರ ವಿರುದ್ಧ ಸ್ವೀಕೃತವಾಗಿರುವ ದೂರುಗಳು ಅನಧಿಕೃತ ಗೈರು ಹಾಜರಿ, ಕರ್ತವ್ಯ ನಿರ್ಲಕ್ಷ್ಯತೆ, ಬೇಜವಾಬ್ದಾರಿತನ ಮತ್ತು ಕರ್ತವ್ಯದ ಮೇಲೆ ಉದಾಸೀನತೆ ಎಲ್ಲಾ ಕಾರಣಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ದಿನಾಂಕ 31/10/19 ನಡೆದ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ತಾಲೂಕು ಪಂಚಾಯತ್ ಮಧುಗಿರಿ ಇವರ ಅಧ್ಯಕ್ಷದಿಂದ ತಾಲೂಕು ಮಟ್ಟದ ಗ್ರಾಮೀಣ ಪುನರ್ವಸತಿ ಕಾರ್ಯಕ್ರಮ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ಸಭೆಯ ಸದಸ್ಯರು ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸುವ ನಡವಳಿಯಂತೆ ಶ್ರೀ ಸೋಣಸ್ ಅವರನ್ನು 31/10/19 ಅನ್ವಯವಾಗುವಂತೆ ಮಧುಗಿರಿ ತಾಲೂಕು ಪಂಚಾಯತಿ ಉದ್ದೇಶ ಪುನರ್ವಸತಿ ಕರ್ತವ್ಯದಿಂದ ವಜಾಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿ. No opportunity of any sort, my lords, is extended.
What is the procedure prescribed? You are working in where?
My lords, as my lords, MRW, my lords, which is a scheme, my lords, formed under the provisions of, my lord, the Disabilities Act. Lords may kindly have a look at, my lords, annexure A, my lords. The same does not specify, my lords, as to, my lords, the removal of the members. My lords,
No, that scheme is for what?
my lord, for, my lords, the, as a bridge between, my lords, the disabled persons and, my lord, the department. Annexure A, if lords kindly see. ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಏನಕ್ಕೆ ಅಂತ.
No, ನೀವು ಏನು ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ ಎಂಪ್ಲಾಯ್ ಆಗಿರ್ತೀರಾ ಎಲ್ಲಿ?
ಇಲ್ಲ ನಾವು ದಿ ಡಿಸಬಿಲಿಟೀಸ್ ಇದರಿಂದ ರೆಸ್ಪಾನ್ಸ್ ಆಗಿ ಬಂದಿರ್ತೀವಿ. ದೇರ್ ವಿಲ್ ಬಿ ಎ ಕಮಿಟಿ, ಮೈ ಲಾರ್ಡ್. Annexure A makes it clear.
ಶಾಲೆಯಲ್ಲಿ ಮಧ್ಯಂತರ ಬಿಟ್ಟಂತ ಅಂಗವಿಕಲ ಮಕ್ಕಳನ್ನು ಸಾಮಾನ್ಯ ಶಾಲೆಗೆ ಸೇರಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕು. What is their duty, Mr.?
My lords, Annexure A, that's the government order.
Yes, read.
That is, my lords, at page number 16. Your lords may kindly see, my lord, the order portion, my lords.
Yes.
ಅಂಗವಿಕಲರಿಗಾಗಿ NP-RPD ಕಾರ್ಯಕ್ರಮ ಯೋಜನೆಯನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಗೆ ಸೂಚಿಸಿದ ಅಂಗವಿಕಲರಿಗಾಗಿ ಗ್ರಾಮೀಣ ಪುನರ್ವಸತಿ ಕಾರ್ಯಕ್ರಮ ಹೊಸ ಯೋಜನೆಯನ್ನು ಮಾರ್ಗಸೂಚಿಯನ್ನು ರಾಜ್ಯದ ಎಲ್ಲಾ 29 ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಅನುಷ್ಠಾನಗೊಳಿಸಲು ಮಂಜೂರಾತಿ ನೀಡಲಾಗಿದೆ. ಗ್ರಾಮೀಣ ಅಂಗವಿಕಲ ಪುನರ್ವಸತಿ ಕಾರ್ಯಕ್ರಮದ ಮಾರ್ಗಸೂಚಿಗಳು. ಈ ಯೋಜನೆ ರಾಜ್ಯದ ಎಲ್ಲಾ 29 ಜಿಲ್ಲೆಗಳ 126 ತಾಲೂಕುಗಳ ರಾಜ್ಯ ವಲಯದ ಯೋಜನೆಯಡಿ ಅನುಷ್ಠಾನಗೊಳಿಸುವುದು. ಪ್ರತಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಚೇರಿಯಲ್ಲಿ ಸ್ಥಳೀಯ ಸಮರ್ಥ ಅಂಗವಿಕಲರನ್ನು ಪುನರ್ವಸತಿ ಕಾರ್ಯಕ್ರಮದಿಂದ ಗೌರವಧನದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕ ಮಾಡಲಾಗುವುದು. ಇವರು ಗ್ರಾಮದಲ್ಲಿರುವ ಅಂಗವಿಕಲ ಸಮಸ್ಯೆ ಹಾಗೂ ಅಗತ್ಯತೆಗಳನ್ನು ಕುರಿತು ಸೌಲಭ್ಯಗಳ ಅನುಸಾರವಾಗಿ ಸಂಬಂಧಿಸಿ ಇಲಾಖೆಗಳನ್ನು ಸಂಪರ್ಕಿಸಿ ಅಥವಾ ಸಂಪರ್ಕಿಸಲು ಮಾರ್ಗದರ್ಶನ ನೀಡತಕ್ಕದ್ದು. ಇವರಿಗೆ ತಿಂಗಳಿಗೆ 700 ಗೌರವಧನ ಹಾಗೂ 50 ಪ್ರವಾಸ ಲೇಖನ ಸಾಮಗ್ರಿ ವೆಚ್ಚ ನೀಡಲಾಗುತ್ತದೆ. ಇವರು ಕರ್ತವ್ಯಿಸಬೇಕಾದ ಕರ್ತವ್ಯಗಳ ಪಟ್ಟಿಯನ್ನು ಅನುಬಂಧ 1ರಲ್ಲಿ ನಮೂದಿಸಿದೆ. ಇದೇ ರೀತಿ ಪ್ರತಿ ತಾಲೂಕು ಪಂಚಾಯತಿ ಕಚೇರಿಯಲ್ಲಿ ಸ್ಥಳೀಯ ಸಮರ್ಥ ಪದವೀಧರ ಅಂಗವಿಕಲರನ್ನು ವಿವಿಧೋದ್ದೇಶ ಪುನರ್ವಸತಿ ಕಾರ್ಯಕ್ರಮ MRW ಎಂದು ನೇಮಕ ಮಾಡಲಾಗುವುದು. ಇವರಿಗೆ ತಿಂಗಳಿಗೆ 1800 ವೇತನಧನ, ಗೌರವಧನ ಹಾಗೂ 200 ಪ್ರವಾಸ ಲೇಖನ ಸಾಮಗ್ರಿ ವೆಚ್ಚ ನೀಡಲಾಗುವುದು. ಇವರು ತಾಲೂಕಿನ ಎಲ್ಲಾ ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳಲ್ಲಿ ಅಂಗವಿಕಲರ ಅಗತ್ಯತೆಗಳನ್ನು ಪೂರೈಸಲು ಸಂಬಂಧಿತ ಇಲಾಖೆಗಳೊಂದಿಗೆ ಸಮನ್ವಯ ಹೊಂದಲು ಬದ್ಧರಾಗಿರುತ್ತಾರೆ. ಆ ತಾಲೂಕಿನ ಎಲ್ಲಾ VRWಗಳ ಕಾರ್ಯಕ್ರಮವನ್ನು ಇವರು ಪರಿಶೀಲಿಸುತ್ತಾರೆ. ಇವರು ನಿರ್ವಹಿಸುತ್ತಿರುವ ಕರ್ತವ್ಯಗಳ ಪಟ್ಟಿಯನ್ನು ಅನುಬಂಧ 2ರಲ್ಲಿ ನಮೂದಿಸಿದೆ.
Same like ಅಂಗನವಾಡಿ ವರ್ಕರ್ಸ್ ಇವರಿಗೆ they are
There
related
will
to
be bridge
that
between, my lords, those disabled and, my lord, the departments.
departments.
ಅಷ್ಟೇ.
No, but person who has appointed employee is also a physically handicapped person.
Yes, ಹೌದು, ಅವರು. My lords, it is admitted that I have 50% disability.
Yes.
My lords, I commend, my lord,
All the condition for appointment.
my lords, page number 19, ಅದು there is a typographical error, VRW ಅಂತ ಆಗಿದೆ, MRW ಅಂತ ಆಗ್ಬೇಕು. page number 19 ಅಲ್ಲಿ.
Yes.
ಇವರು ಪದವೀಧರರಾಗಿದ್ದು ಸ್ಟಾರ್ಟ್ಸ್ ವಿದೇಶ ಪುನರ್ವಸತಿ ಕಾರ್ಯಕರ್ತರು ಅಂತ ಹೇಳಿ VRW ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅದು ಮಲ್ಟಿಪರ್ಪಸ್ MRW ಆಗ್ಬೇಕು ಅಷ್ಟೇ. ಪೇಜ್ ನಂಬರ್ 19 ಅನುಬಂಧ 2 ಅಂತಿದೆ. Annexure 2 to the order.
But there is no any circular or procedure has been prescribed. How
No, nothing. But my lords, ultimately, on the basis of allegation, my lords, it is done. At least, my lord, they should have, my lords, called upon me to, my lords.
There is no notice.
Nothing.
What is
Complaint received or order is passed?
Yes, Mr.
In the statement of objection was stated that.
Now,
there
what is
a
that? Is
temporary
there any
selection-
stay of this order?
Temporary selection.
Unfortunately, no, my lords. My lords, similar case, my lord, your lordship was considered, my lords, on the other day. That is WP, my lords, 11357 of 2020. Where, my lords, on the ground that, my lord, the disability has been reduced from 40%, 45%, my lord, to 35%. He is relieved without opportunity. Well, that matter is also, my lords, being taken up, my lords, before this court. Where they said the appointment orders are, when they claim that it is with the condition that if any allegation is made out, they can take action.
No, they can take an action because allegation is there.
Please.
But should they not give an opportunity to explain?
Now, that is also not done, and they don't consider the resolution of, my lords, the panchayat also.
No, panchayat resolution is related to your physical.
No, no, no. It says, my lords, ಅಲ್ಲ ಇವರು ಯಾವುದೇ ಗುರುತರವಾದ ಹಣಕಾಸಿನ ದುರುಪಯೋಗ ಪ್ರಕರಣ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು, ಆಮೇಲೆ ಆಗಿದೆಯೋ ಏನೋ, ಬಟ್ ನೋಟಿಸ್.
ಅಲ್ಲಲ್ಲ, ಇದು ರೆಸಲ್ಯೂಷನ್ ಆಗೋದು ದಟ್ ಈಸ್ ಮೈ lords on 5/12/19. That is
What is your
subsequent to,
reply,
my lords,
Mr.?
the order.
Lord, this is a temporary post, Lord, on honorarium basis.
Any
One
post.
thing I did is a clear-cut case of dereliction of duty, bribery, and.
No, principle of
post
natural
release.
justice, you have to give an opportunity. You can't take unilaterally decision, mister. Then if that power is given, then you will misuse that power. If you don't like some person, you will say that go out, I will appoint somebody else. That cannot be done. Have you filed an objection?
Yes, my lord, filed objection.
What is that objection says?
We state that it's a temporary post,
Hmm.
and there is a charges of corruption.
Yes, if
dereliction
there is a
duty and
charges of
everything.
corruption, you give a notice. You are not saying that. Have you stated that notice has been given?
Notice, nothing.
No notice has been given. Yes, we'll ask them to redo it.
Please,
But we will not ask them to reinstatement, mister. You are already out of service from 2019.
Lordship may indicate a time limit so that they will
Yes,
complete the
if
exercise.
they are, see, in that subsequent reply, if they are accepted, then they can be reinstated. Otherwise, they can pass.
My lords, I may be provided opportunity to, my lords, file additional reply, my lords, if it is required.
Yes.
Yes.
In this writ petition, petitioner called in question, order dated 7/11/2019, passed by fourth respondent by the annexure L.
And subsequent, my lords, on 17/10/2020, annexure K, my lords.
What is that?
This order was communicated to me, my lords, with this.
That you have not challenged. No, but that is consequential order.
ಅಲ್ಲ ನನಗೆ ನಿಮ್ಗೆ ಆ ದಿವಸದಿಂದ ಆಗಿದೆ, ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ನಂಗೆ ಇದ್ರ ಜೊತೆನೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಸಿಗೋದು. ನಂಗೆ ಮುಂಚೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ನಂಗೆ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿದ್ದು. ಲಾರ್ಡ್ಸ್ ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅದನ್ನ ಕಾಪಿ ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೇವೆ ಅಂತ.
No, which one? Annexure?
Annexure K, my lords, page number 38. When, my lords, after the
No, that is
panchayat
not-
passes the resolution in my favor, forwarded, the authority,
You are challenging only annexure L.
that is what, my lord, the termination order
That
is.
is what I am saying, that what is that in the prior?
ಅಲ್ಲ ಎಲ್ಲಲ್ಲಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ರು ಅಂತ ಅಷ್ಟೇ ತಮ್ಮ
Yes.
ಪ್ಲೀಸ್.
By annexure L dated 7/11/2019, whereby service of the petitioner has been dismissed from the service. Case of the petitioner that the state government under the provisions of persons with disability bracketally equal opportunities, protection of right and full participation Act 1995 has issued a government order dated 16/8/2007, thereby constituting the post of rehabilitation officer such as village rehabilitation worker and multi-purpose rehabilitation worker. Pursuant to that government order dated 16/8/2007, petitioner has been appointed. Where is your appointment order?
ಅದಕ್ಕೆ they don't, my lords.
No appointment order. When you have been appointed, Mr.
Annexure B, my lord.
If lordships kindly see, my lords, annexure C, 5/2/2008.
Petitioner has been, you are been appointed as what?
My lords, MRW, my lords, multipurpose rehabilitation worker. Duty report ಮಾಡ್ಕೊಂಡಾಗ,
No, what is your post, Mr.?
that is multipurpose rehabilitation worker.
Has been appointed as multi-purpose
Rehabilitation worker.
rehabilitation worker.
Duty report 5, my lords, annexure C, page number 28.
Annexure C na?
Ah,
In the
page
year
number 28.
2008,
Page number 28 ಅಲ್ಲಿ.
in the year 2008,
Please.
pursuant to that, he has reported to the duty on 5/2/2008 as per annexure C. He was working continuously without any break. And things stood that the respondent, which respondent has issued that order?
This is
Respondent.
Jilla,
that is not the
fourth respondent. Fourth respondent has issued an impugn order dismissed that petitioner from the service.
but that was not communicated, my lords, in the beginning.
By order dated 17, by impugn order annexure L. Next para. The specific case of the petitioner that, the counsel for the petitioner that impugn order annexure L dated 7/11/2019 is passed without giving any notice to the petitioner. In fact, the same has not been communicated to the petitioner. He come to know only on 17/10/2020. When they have made a serious allegation against the petitioner without giving any notice, the impugn order has been passed. It violates principle of natural justice against the right guaranteed to the petitioner under Article 14 of Constitution of India. Hence, he sought for allowing that writ petition. The government advocate appearing for respondent has submitted that appointment of the petitioner as shown post on a temporary basis, since there is a serious allegation of corruption, he has been terminated from the service. Hence, he sought for dismissal of the petition. Heard the learned counsel for the parties. It is not in dispute. Petitioner has been appointed as what is that post?
Multipurpose rehabilitation worker,
Multi-purpose rehabilitation
worker.
in the year 2008. The fourth respondent by impugn order annexure L on 7/11.
I'm sorry, notes. Annexure B ನಲ್ಲಿ appointment order ಇದೆ.
Yes, he has been appointed in
28/1/2008.
2008 ಗೆ date ಹಾಕ್ಬಿಡಿ. Annexure B dated
Annexure B, my lords, 28/1/2008. Page number 27 and ನನ್ನ ಹೆಸರು ಇದೆ. It's the order is at 26. 27 serial number 4 is my
has
name.
been appointed at so and so on 28/1/2008.
Please.
By annexure C, he has reported to duty. Fourth respondent has issued an impugn order, Annexure L dated 7/11/2019. Dismiss the petitioner from the service. The said impugn order has been passed without giving any notice to the petitioner. It is clear violation of principle of natural justice. Against the right guaranteed to the petitioner under Article 14 of Constitution of India. The state government has filed a statement of objection. Has not disputed that notice has not been issued to the petitioner before passing an impugn order, Annexure L. On this ground alone, the impugn order, Annexure L, liable to be set aside. Next paragraph. The impugn order has been passed on 7/11/2019. From that day, petitioner is not working. Even though impugn order is liable to be set aside, in the peculiar facts of the case, petitioner cannot be reinstated in the service till that redo that process by the respondent. Accordingly, writ petition is allowed. Order dated 7/11/2019. Annexure L passed by fourth respondent is passed. The competent authority is directed to pass an order after giving an opportunity to the petitioner within 3 months from the date of receipt of the copy of this order. In case if the authority comes to the conclusion that petitioner allegation made against the petitioner is not proved, the authority is directed to reinstate the petitioner into the service. Please.
Serial number 46, K. Srinivasa.
Yes, Mr.
I'll take up the matter, my lord, at 2:30, my lord.
Not 2:30.
So may I
Want password?
I want password, my lord. The other side, my lord, he told that he held up in other court.
Password.
Kindly pass.
Yes.
Serial number 46 pass over. Serial number 47, Shrikant MP.
47, my lord, it is not covered, my lord. Will have to file statement of objection, my lord, in this.
Lords, I argued on the other day. My lords, I submitted, my lords, about the fact that, my lords, when a person from another institution is transferred to another institution aided, there has to be consent of both the managements. Admittedly, on our part, we did not consent, my lords, when a headmaster was transferred to our institution.
No, that is that provision which you have read out.
Yes, my lord, and also the judgment, which says, my lord, there has to be consent. In our case, they say you did not take the candidate we sent, and as such, we'll treat that post as permanently unaided. And my lords, by virtue of that, we are not in a position to appoint any candidate, my lords, in that post. Ultimately, my lord, there is no consent. When there,
Where is that provision?
my lords, the judgment, my lords, which I read to lordships on the other day.
Yes.
My lord, it starts, my lords, at page number 70. The relevant paragraph, my lords, would be at 110, my lords, at para 14 of the order. the rules are read down,
Yes.
saying that, my lords, statute, the provisions contained in
No,
para
having
14.
regard to that complexity, the need to be balanced, equity guided, so on, sir. This court is of the consider opinion, provision of 98 of the Act, 99 required to read down to make it more effective, workable and ensuring attention of the object of the Act. Provision from the matter of transfer teaching employees from one private institution to others shall be done by only with the consent of the governing council managing committee.
Their case is, we sent a candidate, you did not take it. My lord,
Yes,
that
yes,
shows
what you
that, my
said.
lord, there is no consent.
No, that when that transfer has been distinguished.
My lords, the order you have produced, my lords, at annexure L, page number 44,
Date.
on 4/8/2018.
But this judgment is thereafter.
At that time, my lord, the rules were challenged.
You have challenged the rules here also.
Not the institution, not the other institution had challenged, and those petitions were pending before this court. In fact, my lord, your lords may kindly see, in 2012 itself, my lord, the rules were challenged.
Yes, Mr.
I need certain instructions.
Huh?
I need certain instructions, my lord, in this.
No, that the instruction is nothing. See, this court has said.
Yes.
Rule has to be read that after consultation with that management, you can be transfer any employee to that management. Whether the management can be refused or not, it's different. That is, then nothing has been explained. If you say, I will not take it, what is that result?
They cannot go ahead. That is what, my lord,
And what is that government has in a power then? All management.
My lord, that is discussed, my lords, para 12 onwards. My lord, what the TMA case says is that, my lords, yes, you are a government institution, but merely for the reason that you are receiving grants, you cannot be treated as if it is a government-owned institution and any person can be thrust upon you.
Yes.
And subsequent judgment in 2003, my lords, in TMA case again, said all the judgment should be brought in conformity with 2002 8 SCC 482. That was not done. It remained in the statute book as it is. We challenge the provisions. Para 12 onwards, my lord, the discussion is there.
Yes,
My lord,
you know that this court has already held that.
Please.
You have to be.
Please.
Yes, first. Only with that consent of that governing council, managing committee, we can. That means to say, if they say yes, then only, otherwise you can't. Now that, what is that order you are challenging?
My lords, the endorsement which has been issued when we made the proposal for admission, that is for permission notes to appoint CBZ teacher, page number 69, my lords, annexure W. The endorsement is issued saying that you did not get the other person reported. And as such, we will not consider your case.
Where is that?
Page number 69, my lords, annexure W.
ಸದರಿಶಾರ ಆಡಳಿತ ಮಂಡಳಿಯವರು ತಮ್ಮ ಆದೇಶವನ್ನು ಪಾಲನೆ ಮಾಡದೇ ಇರುವುದರಿಂದ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ 20 ಯಾವುದೇ ಆಡಳಿತ ಮಂಡಳಿ ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರು ನಿರಾಕರಿಸಿದಲ್ಲಿ ಅಂತ ಆದೇಶ ಶಾಶ್ವತ ಅನುದಾನ, which is that government order 61/2001.
My lord, I have produced, my lord, the circular where, my lord, directions.
By circular cannot override that provision now.
That is what.
They cannot.
The relevant circular, my lords, was the first endorsement is, my lords, page number 50 on 9/1/2019. My lords, referring to the endorsement of the government, my lord, the director. Next page, my lords, page number 51, annexure P. Adralli, if lordships kindly come to 53, my lords.
53.
Last but one paragraph.
Yes.
ಯಾವುದೇ ಶಾಲಾ ಆಡಳಿತ ಮಂಡಳಿಯವರು ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರನ್ನು ಕರ್ತವ್ಯಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ನಿರಾಕರಿಸಿದ್ದಲ್ಲಿ ಅಂತಹ ಶಾಲೆಯ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಉಲ್ಲೇಖ 2ರ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ಶಾಶ್ವತ ಅನುದಾನ ರಹಿತ ಹುದ್ದೆ ಎಂದು ಘೋಷಿಸಲಾಗುವುದು. Then, my lords, the next page, page number 54, they issue a specific direction, last paragraph. ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರು ಮರು ಹಂಚಿಕೆ ಮಾಡಿದ ಶಾಲೆಗಳ ಖಾಲಿ ಹುದ್ದೆಗಳಿಗೆ ಆಡಳಿತ ಮಂಡಳಿ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಲು ನಿರಾಕರಿಸಿದ್ದು, ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಆ ಶಾಲೆಯ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಅನುದಾನ ರಹಿತ ಎಂದು ಘೋಷಣೆ ಮಾಡಿದ ಪ್ರಕ್ರಿಯೆ ಮಾಡುವುದು ಕಂಡು ಬರುತ್ತಿಲ್ಲ.
Yes, what is your objection? Have you filed an objection?
Yes, madam, we filed objection.
What is the contention you are taking?
We only stated that.
We did not take the candidate to duties.
No, what is your answer regarding that judgment, Mr.? when they have made an annexure, should they not answer in that objection? Yes, what they have given a reply in respect of.
Paragraph 7, my lord. Paragraph 7. First. The post has already been identified. It is only the institution has to accept the retrenchment order passed by the department. The management cannot take its decision.
I3, subsequently there is a judgment of this court.
Yes.
New objection, ಯಾವಾಗ ಹಾಕಿದ್ರ 2024 ಅಲ್ಲಿ
2024. 2022 minute. 22 minute. 15/10/2022.
Judgment is 2021. He has marked as an annexure in that. Yes. What is your answer regarding that? Where is your statement of objection?
15/10.
They don't say anything about it, my lords.
ಎಲ್ಲಿದ್ದಾರೆ objection file ಮಾಡಿಲ್ಲನ್ರಿ?
ಮಾಡಿದ್ದಾರೆ.
File my lord. 15/10/2022 my lord, it is filed. Fifteen 10/2022. 18/10 my lord. 18/10.
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಯಾಕೆ ಅರ್ಜೆಂಟ್ ಆಗಿತ್ತ?
ಅವ್ರು ಇರಲಿಲ್ಲ ಅಂತ ಕನ್ಸರ್ನ್ಡ್ ಅಡ್ವೊಕೇಟ್ ಇರಲ್ಲ ಅಂತ ಪಾಸ್ ಓವರ್ ತಗೊಂಡ್ರು ಆಮೇಲೆ.
Yes, you are appearing in this matter.
Yes ma'am. I am.
Then what is that your submission regarding that judgment?
Judgment.
What is that you have replied in this statement of objection?
ಇದರಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ. Judgment ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ.
ಮತ್ತೆ management had not accepted that order passed by the department, hence the department passed an order seizing the post of the headmaster is treated as a permanent unneeded post. ಯಾವುದೋ ಒಂದು ರೀಸನ್ ಬೇಕು ನಿಮಗೆ ಅನ್ಎಡೆಡ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ, ದುಡ್ಡು ಕೊಡಕ. Then you take this as an yes. Petitioner has filed this petition under Article 226 of Constitution of India, challenging in circular P n challenge ಮಾಡಿದ್ದೀರಾ? Why you have challenged the PWS and all?
My lord, the circular by which, my lord, they were directed to treat it as unauthorized, that is unaided post, and the endorsements which are issued thereupon.
No, that you are pressing for that circular.
Not, my lord.
Now that in view of that judgment, it need not be.
Yes, my lord.
Which are that now that you are seeking only endorsement?
Endorsements, my lords, that is annexure W.
W is the endorsement.
And my lords, seeking for
to consider that representation of the petitioner. MQS, what is that MQS?
That is for my lords filling up of the post of
yes,
teacher.
Terminate counsel for first leader. Terminate counsel for the petitioner submits that. We will not press prior A. Submission is taken on record. The petitioner has called in question the endorsement dated 9/11/2021 issued by third respondent with annexure W, whereby post of ಯಾವ್ದ್ರನ್ನ ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರು ಅಂತ ಹಾಕಿದ್ದಾರೆ? You said principal. Which post, Mr.?
ಅಲ್ಲ ಅವ್ರು HM ನಮಗ್ ಕಳ್ಸಿದ್ರು, ಇನ್ HM ಅಂತಾನೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರು ನಮ್ಗೆ.
ನೋ, ಆದೇಶವು ಯಾವುದೇ ಆಡಳಿತ ಮಂಡಳಿ ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರ ಕರ್ತವ್ಯವನ್ನು ತೆಗೆದುಕೊಳ್ಳಲು ನಿರಾಕರಿಸಿದಲ್ಲಿ ಅಂತ ಹುದ್ದೆಯನ್ನು
ಇಲ್ಲಿ ನಮ್ ಕೇಸಲ್ಲಿ ಹೆಡ್ ಮಾಸ್ಟರ್ ಆಫ್ ಅನದರ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ವಾಸ್ ಪೋಸ್ಟೆಡ್ as ಹೆಡ್ ಮಾಸ್ಟರ್ ಇನ್ ಅವರ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್.
Now you have sent it for an headmaster.
ಹೌದು, ಅವ್ರು ಹೆಡ್ ಮಾಸ್ಟರ್ನೇ ಕಳ್ಸಿದ್ರು ನಮ್ annexure L page number 44.
Whereby post of headmaster in first petitioner institution.
Institution run by the petitioner management.
Yes.
It runs my lord several institutions.
Yes.
Vishwabharati Prodashale, Melekote, Tumkur Taluk.
First petitioner
Please.
has been treated as non-grant post. First petitioner is in a society registered under the Society Registration Act. It is running 4 aided high schools. Shri Vishwa Bharati aided high school is the one of them.
Melekote, Tumkur Taluk notes is the.
Vishwa Bharati aided high school, Melkote, Tumkur.
Melekote,
Melakote.
Melekote, Tumkur
Melakote,
Taluk.
Tumkur is also one of them. The post of the headmaster of the said high school was admitted to the grant. Where is that transfer order?
Page number 144 minutes, annexure L.
Page number?
44.
ಅದೇ ನಿಮ್ದು ವೇಕೆಂಟ್ ಆಯ್ತಾ?
Vacant ಇತ್ತು, ಇನ್ಚಾರ್ಜ್ ಅರೇಂಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇತ್ತು.
Yes. When it's become vacant?
Not that, the information, not, your lordship kindly have it, annexure W into an endorsement ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
Yes.
ಅವ್ರು ನಾವು ಪ್ರಮೋಷನ್ ಕೊಡ್ತೀವಿ 31/8/15 ವೇಕೆಂಟ್ ಆಗುತ್ತೆ.
The said post become vacant
On
31/8/2015.
Please.
Thereafter, the management was given a in-charge arrangement.
Because of economy measure and other aspects, my lord, they were not approving. That's why we had
Yes.
to place somebody else.
Then when they have sent it to the teachers to your
Page number 44, annexure L, on 4/8/2018.
page number
44,
44.
please.
On 4/8/2018, Upanirdeshakaru respondent number?
4.
The respondent number 4 issued a communication
Posting order, ಸ್ಥಳ ಸಂಚಿಕೆ ಆದೇಶ ಅಂತ.
by the annexure L 4/8/2018 issued a communication posting order
Please.
on 4/8/2018. Posted one Sri Nagaraj as a headmaster of Vishwa Bharati High School, Melekote, Tumkur. The petitioner management has not accepted the same. Thereafter, the management has sent in a proposal. ಏನು ಪ್ರಪೋಸಲ್ ಪ್ರಮೋಷನ್ ಅಥವಾ ಫಿಲ್ ಅಪ್ ಪೋಸ್ಟ್?
ಅದು ಅಲ್ಲಿ ಪ್ರಮೋಷನ್ ಟು ದಿ ಪೋಸ್ಟ್ ಆಫ್ HM and not permission to appoint candidate to the post of assistant teacher.
Yes. Send in a proposal seeking a permission. Permission ಕೇಳಿದ್ರಾ ಅಥವಾ ಪ್ರಪೋಸಲ್ ಕಳಿಸಿದ್ರಾ along with that name?
To proposal ಕೊಟ್ವಿ, ಆಮೇಲೆ representations ಕೊಟ್ವಿ.
Yes.
Ultimately
Send in
it
a
was
proposal
rejected.
to approve the
Grant
promotion
permission, to grant permission to fill up the post of HM.
Yes. Send a proposal to approve that.
First to
Promotion.
permission to appoint, permission to fill up.
No. First you have to be.
First permission ತಗೋಬೇಕು fill up ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ.
Promotion ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿದ್ರು ಅದನ್ನೇ
ಅಲ್ಲ
ಕೇಳ್ತಾರೆ.
ಇಂಥವ್ರು ಪ್ರಮೋಷನ್ ಕೊಡ್ಬೇಕು ಅಂತ ದಿ ಸೀನಿಯರ್ ಮೋಸ್ಟ್ ಕ್ಯಾಂಡಿಡೇಟ್ ವಿ ವಾಂಟೆಡ್ ಟು ಪ್ರಮೋಟ್.
What I am asking, whether it's in a proposal for, you are the permission or the proposal?
It only says, my lords,
I
promote, your lordship can say,
Not an-
sought permission to, my lords,
sought a
promote.
permission to promote that senior most teacher as an headmaster, and also sought a promotion to fill up that
Permission.
sought a permission to fill up that vacant teaching post. Their request has been rejected by impugned endorsement annexure W. On the ground that the management has refused to accept the transfer order or the posting order issued by fourth respondent. And also on the ground that rejected. Learned counsel appearing for the petitioner has submitted that when the fourth respondent has passed a posting order wide annexure.
W, my lords, page number.
No, posting order headmaster
The page number 44.
wide annexure L dated 4/8/2018. They have not consulted that management. Therefore, such a posting order is not binding on the management. He contended that High Court in WP number 33101 of 2014 and connected matter on 30th March 2021 has considered the provisions of subsection 2 and 3 of section 98 of Karnataka Education Act 1983 and Karnataka Education Institution bracketed recruitment, term and conditions of service of employees in private aided primary and secondary education institutions rules 1999. Has held that posting or transfer of the teacher from one private aided institution to the other shall be done only with the consent of the governing council or a managing committee. Since no such consent has been taken, therefore their permission to fill up the post of headmaster cannot be rejected on that ground. Hence he sought for allowing that writ petition. Per contra, government advocate appearing for respondent state has contended that the authority has passed a posting order wide annexure L posted 1C Nagaraj as headmaster to Vishwa Bharati Prouda Shale. The same has not been accepted by the management. When that management has, when the institution is aided institution, they have to obey the directions issued by the government. Since they have disobeyed the directions of the government, the request of the petitioner for permission to fill up the post of headmaster is rejected. Heard the learned counsel for the parties. Peruse, read paper. The first petitioner, Vishwa Bharati Education Society, is running a Vishwa Bharati aided high school, Melkote, Tumkur. It is a aided institution. In the said institution, post of the headmaster has become vacant. By Annexure L dated 4/8/2018, fourth respondent has posted 1C Nagaraj as a headmaster. The management has not accepted the same. Thereafter, management has sent management has submitted a representation seeking a permission to fill up that post of headmaster. Said request has been rejected by impugn endorsement on the ground that the management has refused to comply the directions issued by the authority vide Annexure L. This court in batch of writ petition in WP number 33101 of 2014 disposed of on 30th March 2021. Page 110 ಅಲ್ಲಿ para 14 ಇದೆ extract ಮಾಡಿ. From the above judgment, it is very clear that the government wants to allocating / transferring a teacher / employee from one private aided institution to another shall be done only with the consent of the governing council / managing committee. In the case in hand, before passing the posting order Annexure L dated 4/8/2018, the authority has not consulted the managing committee. In view of the judgment of this court in WP 33101 of 2014 on connected matter disposed of on 30th March 2021, the impugn order annexure W has passed. Accordingly, writ petition is allowed. Impugn order annexure W is passed. Respondent is directed to consider that. ನಿಮ್ದು ಯಾವ್ದ್ರಿ representation? ನಿಮ್ಮ ಪತ್ರ ಅದೇನಾ 15/3/21.
Fourth respondent should forward, my lords. Fourth respondent, he should forward the proposals, my lords.
No, now that you have already sent in a proposal.
That, my lords, is rejected by the director, the third respondent.
No, that which is your proposal? We will direct the third respondent to keeping in view of the judgment, let him consider.
Reconsider.
Yes. Where is that?
My lords, that is the, my lords, the.
ಅಲ್ಲಿ reference 6 ಇದೆಯಲ್ಲ ಅದೇ ಅಲ್ಲನ್ರಿ?
Illi that is, my lords, I have produced also, which I read to your lordships just.
Annexure?
That is annexure W, page number 69.
Annexure?
W, page number 69.
Is the impugn order?
Yes, my lord. ಅದರಲ್ಲೇ ಅವರು ಪ್ರಪೋಸಲ್ ಕಳಿಸಿದ್ರು, ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ವಾಪಸ್ ಕಳಿಸ್ತಾರೆ.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು, ಅದ್ರಲ್ಲಿ ರೆಫರೆನ್ಸ್ 6 ಇದೆಯಲ್ಲ, is it your proposal, mister?
ಅಲ್ಲ, ಅದು that is from the my lords, the department. ಅದು
ಪತ್ರ ಸಂಖ್ಯೆ ಅಂತಿದೆ.
ಅಲ್ಲ, ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್ ಗೆ ಅಡ್ರೆಸ್ ಮಾಡಿದ್ದಾರೆ, ಅವರ ಪತ್ರ ಅದು.
ನಿಮ್ದು ರೆಫರೆನ್ಸ್ ಇಲ್ವಾ?
ಇದರಲ್ಲಿ ಇಲ್ಲ.
ನಿಮ್ದು ಎಲ್ಲಿದೆ ಅಥವಾ annexures ಮಾಡಿದ್ದೀರಾ? Where is your request, mister? Where is your request, mister? ಇಲ್ಲಿ ಏನೋ annexure Q ಇದೆಯಲ್ಲ, ಏನದು?
If lordships kindly have, my lords, annexure V. Annexure V ನಲ್ಲಿ
Q ಏನದು?
ಅಲ್ಲ, representations ಕೊಟ್ಟಿದ್ದೇವೆ ಉದ್ದಕ್ಕೆ.
ಏನಕ್ಕೆ ಕೊಟ್ಟಿದ್ರು represent?
ಅದೇ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ. That is what, my lords, ultimately we are seeking.
See, now when it is quashed, they have to be reconsider that.
Yes, that is
representation in terms of that judgment.
That is M, Q and S, my lords.
M, Q and S. The respondent's authority are directed to reconsider the case of that petitioner afresh in accordance with law, keeping in view of judgment of this court in WP number 33101 of 2014 and connected matter disposed of on 30th March 2021. Yes.
Please, lordship may prescribe time limit so that
in 6 months from date of
ಅಲ್ಲ 3 months ಯಾಕಂದ್ರೆ
ಅವರು ಇನ್ನೊಬ್ಬನಿಗೆ ಫಾರ್ವರ್ಡ್ ಮಾಡಬೇಕು.
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ ಡಿಫಿಕಲ್ಟಿ ಆಗ್ಬಿಡ್ತೀನಿ. The candidate, my lords, who is appointed, the second petitioner, she has crossed the age limit, but now the my lords,
now the point is that
please,
when they have passed an order that was in force.
Yes,
provision was in
no,
force.
What I'm trying to say is, my lords, is
now
this.
That whether this judgment can be applied or not, they are.
ಅಲ್ಲ, one ನಿಮಿಷ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ. Difficulty is she has already crossed.
Get ready for second round of litigation.
ಅಲ್ಲ, ಅದಕ್ಕೆ 4 ತಿಂಗಳ ಬದಲು 2 ತಿಂಗಳು ಅಂತ ಮಾಡಿದ್ರೆ.
Yes, within 4 months from date of.
ಅಲ್ಲ, within
4 months, let us.
ಅಲ್ಲ, 4 months ಅದು they will again keep quiet. ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬೇಕಾಗತ್ತೆ.
ನೀವು ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬೇಕು.
ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ, ಅದಾದ್ಮೇಲೆ ಪರ್ಮಿಷನ್ ಕೊಡೋ ಮತ್ತೆ ಏಜ್ ಆಗುತ್ತೆ.
Within 3 months from date
please.
Of first of all. Yes.
Please.
Serial number 48.
For the response in this case, my lord, the state of objection, everything is ready. It has to be signed and filed, my lord. Just 1 week time may be granted in this case.
Yes, at the request of counsel for the petitioner.
Respond, my lords.
Use this matter next week in B group.
Please, lords.
Yes.
Serial number 49.
For petitioner.
No, it's.
Lords, the institution where we were working, my lords, was shifted from Bangalore to, my lords, Chittorgarh district, that is Karikere, my lords, Chalkere Taluk. The department was about to consider our representations. There, my lords, we faced a difficulty. Your lordships are aware, my lords, the department took a decision that if the institution, my lords, is shifted, or, my lord, there is change in that is composition, that is governing council, the institution should obtain fresh recognition. And the rules said, my lords, that a fresh registration recognition to be obtained. became subject matter of challenge before this honorable court, argued at length, my lord, the court, my lord, ruled in favor of the rules. By virtue of that, my lord, the appointment was not being approved. However, my lords, the government passed an order subsequently,
I
my
think
lords.
that rule I have argued and.
Yes, my lords, we were.
Yes, I can remember.
That, my lords, was relaxed, my lords, by the government.
Yes.
By passing a government order, which is at, my lords, Annexure E, page number 92.
What is that?
That is, my lords, they excluded those institutions where it is shifted, saying that it is only for the purpose of, my lords, providing amenities and good infrastructure, they are to be shifted. They said such institution can be considered for granting it.
Yes.
Annexure E, page number 92. Proposals were pending.
Your institution is covered under that.
Yes, we come under that. But insofar as the approval of appointment is concerned, thereafter some dispute, my lords, arose between the management and the teachers. The management started claiming that they have dismissed one person.
Yes.
From service, and also, my lords, tried to, my lords, seek permission to appoint fresh candidates in our place. We made representation, my lord, that is stalled. Now the limited prayer in this case is, my lords, we are seeking for, my lords, our approval to the post, my lords, where we were working. Lakshmi, the difficulty what I face, my lords, if I seek for only consideration would be, they have, my lords, communicated to the department, my lords, saying that we have dismissed the services of, my lords, one candidate, and that they are, my lords, going for appointment of others, or rather for other posts. Now, in that situation, consider andre may not be, my lords, of, let there be, my lords, an inquiry, and, my lords, let the department, my lords, then consider about, my lords, our case.
Yes, Mr. Government.
One aided institute shifted one place to another, has to be treated as a new institute, and they have to make a separate fresh application.
Then that grant in aid, everything has to be fresh. Now, what is this government order?
Alla grant in aid continue ಮಾಡಬಹುದು ಅಂತಂದ್ರೆ. That in fact, my lord,
that registration has to be obtained.
Annexure, annexure, that is C, page number 30 is the order of this honorable court.
Yes.
Which your lordships referred to, my lords.
Yes. Page number?
That is, it starts at page number 30. 30. Lords, two provisions, my lords, under the rules were challenged. The section 41(5) says only recognition to be obtained as if it is a newly started institution. But the rules which are framed prescribes that I have to obtain registration and recognition as if it is a newly started institution. The rules, my lord, the challenge was considered, held, my lords, in favor of the rules. Thereafter, my lords, in fact, my lord, the petitioners were also before this honorable court. My lords, in fact, that management did not approach the division bench by filing an appeal because of the government order which was issued subsequently. They became entitled, and my lords, they got the grant in aid.
Yes.
My lords, the other, this institution, the employees also, my lords, tried to, my lords, challenge the order, but unfortunately their appeal was rejected. But as, my lords, the government order at page number, that is, my lords, which I referred to now, 92, came to be issued.
Yes.
Their request was sought to be considered in terms of that government order. Otherly, if you lords kindly take, my lords, page number 92. ಉಲ್ಲೇಖ ಎರಡು ಸರ್ಕಾರ ಸುತ್ತಲೇ ಕೆಳಗಂಡ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲಾಗಿತ್ತು. ಸದರಿ ಹಸ್ತಾಂತರ ಅಥವಾ ಸ್ಥಳಾಂತರದ ಸರ್ಕಾರದ ಪೂರ್ವಾನುಮತಿ ಕಡ್ಡಾಯವಾಗಿ ಪಡೆಯತಕ್ಕದ್ದು ಹಾಗೂ ಪೂರ್ವಾನುಮತಿ ಪ್ರಕರಣಗಳ ಅನುದಾನಿತ ಸಿಬ್ಬಂದಿಗೆ ವೇತನವನ್ನು ಮುಂದುವರಿಸತಕ್ಕದ್ದು ಎಂಬ ಮೂಲಕ ಸ್ಪಷ್ಟೀಕರಿಸಿದೆ. ನಂತರದಲ್ಲಿ ಉಲ್ಲೇಖ 3ರ ಸರ್ಕಾರದ ಸುತ್ತಲೇ ಹಸ್ತಾಂತರ ಸ್ಥಳಾಂತರ ಮಾಡಲಾದ ಶಾಲೆಗಳನ್ನು ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಕಾಯ್ದೆ ಸೋನ್ಸು ಅಡಿ ಹೊಸ ಶಾಲೆಗಳನ್ನು ಪರಿಗಣಿಸಿ ಅನುದಾನಿತ ಸೌಲಭ್ಯವನ್ನು ವಿಸ್ತರಿಸದಿರಲು ತಿಳಿಸಲಾಗಿದ್ದು, ಈ ಸುತ್ತಲೇ ಅನುದಾನಿತ ಶಾಲಾ ಕಾಲೇಜು ಹಸ್ತಾಂತರ ಸ್ಥಳಾಂತರಗೊಂಡ ನಂತರ ಹಿಂದಿನ ಜ್ಯೇಷ್ಠತೆಯನ್ನು ಯಾವುದೇ ಸೌಲಭ್ಯಕ್ಕೆ ಪರಿಗಣಿಸಲು ಮತ್ತು ಹಸ್ತಾಂತರ ಸ್ಥಳಾಂತರಗೊಂಡ ನಂತರ ಆ ಶಾಲಾ ಕಾಲೇಜುಗಳನ್ನು ಹೊಸ ಶಾಲಾ ಕಾಲೇಜುಗಳನ್ನು ಪರಿಗಣಿಸುವುದರಿಂದ ಇಂತಹ ಶಾಲಾ ಕಾಲೇಜುಗಳು ವೇತನದ ಅರ್ಹತೆಗೆ ಪರಿಗಣಿಸತಕ್ಕದ್ದೆಂದು ಸುತ್ತೋಲೆಯಲ್ಲಿ ತಿಳಿಸಲಾಗಿತ್ತು. ಇದರ ಮುಖ್ಯ ಉದ್ದೇಶ ಶಾಲೆಗಳು ಮಾರಾಟವಾಗಬಾರದು ಎಂಬುದಾಗಿದೆ. ದಿನಾಂಕ 29/17 ಸುತ್ತೋಲೆ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈಗಾಗಲೇ ಅನುದಾನ ಪಡೆದಿರುವ ಸ್ಥಳಾಂತರಗೊಂಡ ಶಾಲೆಗಳಿಗೆ ವೇತನವನ್ನು ಮುಂದುವರಿಸಬೇಕೇ ಎಂಬ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಣ ಕುರಿತು ಅನುದಾನಿತ ಶಾಲಾ ಕಾಲೇಜುಗಳು ಉತ್ತಮ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳನ್ನು ಕಲ್ಪಿಸಿಕೊಳ್ಳುವ ದೃಷ್ಟಿಯಿಂದ ಸರ್ಕಾರದ ಪೂರ್ವಾನುಮತಿಯೊಂದಿಗೆ ಸ್ಥಳಾಂತರಗೊಳ್ಳುವುದರಿಂದ ಈ ರೀತಿಯ ಶಾಲಾ ಕಾಲೇಜುಗಳು ದಿನಾಂಕ 29/17 ಸುತ್ತೋಲೆ ಅನ್ವಯಿಸುವುದಿಲ್ಲ. ಆದ್ರೆ ಹಸ್ತಾಂತರದ ಪ್ರಕರಣಗಳು ದಿನಾಂಕ 29/6/17 ಸುತ್ತಲೇ ಅನ್ವಯವಾಗುತ್ತದೆ. ಆದ್ರಿಂದ ಈಗಾಗಲೇ ವೇತನವನ್ನು ಪಡೆಯುತ್ತಿರುವ ಸ್ಥಳಾಂತರದ ಶಾಲಾ ಕಾಲೇಜುಗಳು ವೇತನವನ್ನು ಪಡೆಯಲು ಅರ್ಹತೆ ಹೊಂದುವುದರಿಂದ ಅಂತಹ ಶಾಲಾ ಕಾಲೇಜುಗಳ ಅನುದಾನಿತ ಸಿಬ್ಬಂದಿಗಳ ವೇತನ ಮುಂದುವರಿಸುವಂತೆ ಮತ್ತು ಅಲ್ಲಿನ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಅನುದಾನ ಸಹಿತ ಭರ್ತಿ ಮಾಡುವ ಬಗ್ಗೆ ಅಗತ್ಯ ಕ್ರಮ ವಹಿಸುವಂತೆ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲು ನಿರ್ದೇಶಿಸಲಿದ್ದೇನೆ. So where my lord, only the shifting of institution, change in location.
This is, they sought for a clarification.
Yeah, earlier my lord, both my lord shifting that is change in location and my lord change in governing council, my lord said not possible. It was clarified by saying that only insofar as change in location it can be considered and not for change in governing council.
ಸಿಬ್ಬಂದಿ ಮುಂದುವರಿಸಿ ಮತ್ತು ಅಲ್ಲಿ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಅನುದಾನ ಸಹಿತ ಭರ್ತಿ ಮಾಡುವ ಬಗ್ಗೆ ಅಗತ್ಯ ಕ್ರಮ ವಹಿಸುವಂತೆ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲು ನಿರ್ದೇಶಿಸಲ್ಪಟ್ಟಿದ್ದೇನೆ.
When vacancies arose my lords, in such institution which are already admitted to grant in it, they said if there is change in location, it can be considered by this order. In view of this my lords, our proposals were being considered.
This is not an order, he has written a letter.
So only clarification by the government.
ಹೌದು, ಇದಾದ್ಮೇಲೆ my lord, in fact my lord, the government relaxed. My lord,
there is that government order which relaxed that condition.
This clarification indane.
Clarification, it's in a letter communication.
ಹೌದು, because of this
has no force at all.
ಅಲ್ಲಲ್ಲ,
it cannot override that statutes, Mr. ಅವ್ರು ಯಾರ ಸೆಕ್ರೆಟರಿ ಬೇಕಾಗಿತ್ತು ಅವ್ರು ಲೆಟರ್ ಬರೆದಿದ್ದಾರೆ.
ಆದ್ರೂ ಆಮೇಲಿಂದ
considered as an statutory force.
My lords, that is my lords, the decision your lordship ಅಲ್ಲಿ grant ಕೊಡಲ್ಲ ಅಂತ ರೂಲ್ಸ್ ಇಲ್ಲ. It only said that my lord, they should obtain fresh registration and recognition as if it is a newly started institution.
What is the meaning of newly started?
As if it is a newly started institution, but that was interpreted earlier by circular saying that it will be a newly started institution, will not extend. Then it was clarified, the circular was clarified. I mean, there is no change in my lord legal position. The circular clarified will consider where there is a change in location, but not where there is change in.
Where is that circular? I am asking that.
The earlier circular which was quashed.
No. Now that subsequent clarification.
Subsequently, my lord, this is the communication, and in pursuance of this, my lord, many institutions have been brought under granting.
Now, where is the quashing of the circular? Where is that order which quashed that circular?
No, there is no such order, but only clarification issued later on. After the order of the dishonorable court, this clarification was issued by government.
But this is a letter communication.
Alla, but fact is that my lord, they have been my lords extending granting it to the institution. Now my lords, we are one step ahead of that. My lords, our proposals were also my lords made for my lord the approval. It was pending at that time. My lord, there was some
No, that's, are you discriminating between that one management to other management? You are granting somebody else.
ಇಲ್ಲ ಆತರ ನಮ್ಗಾಗಿಲ್ಲ. ನಮ್ಮ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಫಸ್ಟ್ ನಮ್ ಹೆಸರು ಕಳಿಸ್ತಾರೆ, ನಮಗೂ ಅವ್ರಿಗೂ ಸ್ವಲ್ಪ ತೊಂದರೆ ಆಗತ್ತೆ, ನಮಗೂ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ಗೂ. Then what the management does is that they say we have one of the person is dismissed from service and all others are not attending the institution. ಅವ್ರದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಡಿ, ನಮ್ಗೆ ಹೊಸದಾಗಿ ತುಂಬಿಕೊಳ್ಳೋ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ. That proposal is now pending.
Management is taking that advantage.
Yes. In fact, my lord, they were my lords before this court along my lords with us when we filed an appeal before this honorable court challenging that order, seeking leave my lords be preferred. Well, that was ultimately dismissed, my lord. That's a different issue. But as this order was there, my lords, our proposal was being considered. As sandarbhadalli this issue happened. Now we are being left out. The concern from our side is, my lords, if you lordships can only direct them to consider our case.
Yes.
ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ, ಟರ್ಮಿನೇಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಐ ವಿಲ್ ಶೋ ಮೈ ಲಾರ್ಡ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಆಲ್ಸೋ.
Proposal, your lordship, the
Objection
annexure is
ಹಾಕಿದ್ದೀರಾ?
the clarification.
ಇಲ್ಲ,
Have you filed an objection? Objection ಹಾಕಿದಾರಾ?
We have filed that.
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ನವ್ರ ಸ್ಟ್ಯಾಂಡ್, ಇಫ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್
Filed
annexure
objection,
H.
Where is that objection?
My lords, page number 103.
Objection ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ಯಾರು ಹಾಕಿಲ್ಲ.
22/4/2005.
Objection is not filed, mister.
ಇಲ್ಲ ಇದೆ, but ಫೈಲ್ ಆಗಿಲ್ಲ ಅಂತ.
ಅವರಿಗೂ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
ಗೊತ್ತಿಲ್ಲ, ಫೈಲ್ ಆಗಿಲ್ಲ, ಇದ್ರಲ್ಲಿ ರೆಡಿ ಇದೆ.
Give that copy.
Please.
Yes. Government advocate pays weeks time to file statement of objection. Leave this matter next week.
Please.
Let us see what their stand.
Serial number 50 adjourned. Serial number 51. Ahmed will approve one.
Yes. Yes, none appears. Leave this matter next week.
Serial number 52 adjourned. Serial number 53, Shrikant MP.
Krishna is an employee of Chitrakala Parishad. They have not their own set of cadre and recruitment rules. 53.
Pardon me, Your Lordship, serial number 51. Just came from the other court, Your Lordship, may kindly hear it.
Nobody is there.
Covered matter, Your Lordship.
Pass on.
It's not covered, my lord. It is not covered. It is relating to absorption, no, no. We'll file objections, my lord.
Your Lordship, already objections has been filed, Your Lordship.
No, no, it's not.
Since 3-4.
Objection is
days we have
filed.
not-
No, no, no.
Filed, Your Lordship.
Objection is not filed.
Not filed.
Not
They are
filed.
saying that not filed.
Not
You are saying
filed.
that filed. What is
Your
this?
Lordship, respondent number 6 has already filed the objection.
Who has to
Fairly
answer?
covered
Six.
matter. I'll argue the matter if Your Lordship may.
Pass on. Pass on.
Please.
Yes.
Lords, the institution, Lords, is aided. It's a, Lords, the aid is not as like, Lord, the regular granting aid, but Lord, budgetary allocation made every year. But Lords, the appointments, Lord, service conditions are regulated by.
What is
Lords,
that budgetary made every year? Is it there such a?
these are fine arts institutions, Lord, Chitrakala Parishad.
There's a different. Yes.
That's a different granting aid, not unlike, Lord, the salary grants which are
Yes.
extended.
Yes.
Lord's Annexure H is the cadre and recruitment rules. Insofar as Lord's filling up of the post of principals in the institution.
Yes.
Lords may kindly come to Lord's page number 47.
Yes. Yes.
It says, Lord's principal, method of recruitment. By promotion from cadre of professor, reader, if no suitable person is available for promotion by direct recruitment.
Yes.
They should consider, my lords, the in-house persons
Yes.
eligible, and then, my lords, they should consider for direct recruitment.
Yes.
It's a matter of fact that, my lords, me and my lords, the management had some problem initially. I was successful before the educational tribunal came back.
Yes.
They issued notification without prejudice to my rights. My lords, I participated in this election process. My lords, I am a PhD, my lords, in fine arts.
Yes.
And my lords, I've been working there, my lords, if your lordships kindly see, my lord, the certificates, my lords, which I have produced. And after that, my lords, your
Now
lordships,
that, what is that order you are challenging?
what has happened later on is that, my lords, though, my lords, I was working, my lords, in the institution from 1996. My lords, had the PhD in the year 2010. My student is now, my lords, directly recruited as principal of the institution, ignoring my lord's candidature.
That first option has not been considered.
That is not considered. In fact, when the matter was taken up on the other day, your lordship specifically posed that question, whether it has been done. They have not, my lords.
Why it is urgent for their request?
For their say, my lords, regarding that. My lord, the management, the institution appeared. And my lords, they were supposed to, my lords, show to your lordships that they performed, my lords, the.
Is it the institution has requested for posting appointment of this thing?
No, no, they, my lords, go for, they get grants, my lords, from the government as well as from other institutions. My lord, first, they are, my
Now,
lords,
who has passed an appointment order?
my lord, that is the management.
Where is that order?
My lords, that's what I said. My lords, when I make an application, asking them to, my lords, provide me with a document. Your lords may kindly.
Who is that council appearing for the management?
53.
I appeal for the management,
Yes.
but I seek for a week's time, my lord.
Why,
After, see, I've sought for documents as well from the party.
The difficulty what I am facing is when I make an application for providing me with the copies of the selection process, appointment order of the private respondent, they don't give. I make an application under Right to Information Act. They issue an endorsement saying that Act does not apply to our institution. They don't give. That's why, my lord, the first prayer is to secure the documents from the institution.
Yes, Mr.
Lord, that is entirely a different aspect, my lord. An external jury was formed only insofar as the recruitment is concerned. It is not the college that is decided. External jury, the members all over from India were formed and a decision has been made. And the petitioner is also a party in that. And the senior most candidate, my lord, is not the petitioner, it is someone else. I will just Place it before your lordship, the senior relation.
You take a break, then 2 minutes, then you can argue. Yes.
I'm not arguing, my lord. I'm seeking for a short accommodation. I
No,
want
the
1 week's
only,
time. I will
why
place,
you have to be answered that first criteria is to given a promotion if their eligible candidates are there.
please, my lord.
If nobody is available, then you can go for a direct recruitment.
Please, my lord.
Have that done? Or is it your case that nobody is eligible?
Who is eligible is
Find
my
that.
case, my lord. I'll place it before your lordship, some
Such,
certain documents.
such determination was never done. Lords, I've been working, I'm not, I'm made to, my lord,
Even before this court, if they satisfied that
please.
nobody is eligible.
That's a different issue. What I'm trying to say is, my lords, my lords, they made me, my lords, irrespective of the provisions under UGC regulations. From the beginning, my lords, I am made to struggle, my lords, as by, my lords, my post is treated according to them as assistant professor. Though, my lords, they grant, my lord, they issue all documents as professor. They don't issue a formal order. Now everything is sought to be withdrawn, including identity card, after I filed the writ petition, where it says I am a professor.
Let us see that.
Yes, that precisely, my lord, that's why I wanted the documents to be produced before this court.
Yes, yes. When do you want, Mr.?
A week's time, my lord, next Thursday or Friday.
At the request of counsel for respondent number?
Even.
More. Respondent number 4 or 5?
5, my lord.
5.
Institution.
Yes, as a last chance, use this matter on 26th.
Good.
Yes.
Lords, before that date, let my lords, the other side provide me with copies of what the documents
serve the
are, so
copy.
that I'll be in a position.
I'll serve the copy.
Yes.
Right.
Please.
Serial number 54, Vijay Kumar.
Yes.
Just for the petitioner, Lord, this is the matter, my lords, your lordships have heard at length on the last occasion, Lord, the learned.
Yes. Just give the brief facts, Mr.
Lord, the matter relates to suspension. Lord, I am in the care of assistant executive engineer, my lord. I have been kept under suspension by an order dated 5/3/2024, annexure D. In connected matter, may I request my lord to kindly take 7337 of 2024.
Yes.
5/3/2024, my lord, is the
Yes.
order of suspension passed by the managing director. Tom.
Yes.
Managing Director BESCOM is the, my lord, author of the suspension order. Lords, I pointed out to your lordships on the last occasion that in the objections filed by my learned friend, Lord, he is the incompetent authority, Lord. He cannot keep me under suspension since he is an appellate authority. Lords, kindly come to the objections submitted by my learned friend, Lords, annexure R3. Annexure R3, page 11. Lord, relevant is at page 12, my lord.
Yes.
From bottom, Lord, second, assistant executive engineer electrical.
You are the assistant executive engineer
Yes, my lord.
electrical.
Yes, my lord. Lord, the chart shows, my lords, the existing prior to 2011, what was the rule, and thereafter, my lords, amended in the year 2011. The amended part, my lords can see, lords, the authority empowered to appoint, means appointing authority is the director, admin and HR. My lord, the authority empowered to impose the penalty, lords, for the minor penalties and major penalties. Minor penalties, my lords, is chief engineer electrical KPTCL or chief engineer electrical ESCOMs.
Yes.
And the major penalties, my lords, director, admin and HR.
Yes.
My lords, the minor and major penalties are described in Roman 2 to 4A and 5 to A.
Yes, yes, yes.
My lords, the appellate authority is, my lord, director transmission or MD ESCOMs.
Yes.
He is the appellate authority. He cannot sit as a, my lord, being an appellate authority, my lord, he cannot discharge the duties of a disciplinary authority. My lord, if the disciplinary authority, my lord, is chief engineer electrical KPTCL or chief engineer electrical ESCOM, who is the authority, my lord, who can pass order of suspension. My lord, the questioning the same, my lord, I have to approach the appellate authority, who is the MD ESCOMs. Here is the case, my lord, so MD ESCOM himself have passed the order of suspension. Therefore, my lord, my appeal remedy itself is taken away. On that ground, my lord, MD ESCOMs cannot pass an order of suspension. Is my contention. The major contention is on that, my lord. My lord, in this case, what has happened is, my lord, the order of suspension, my lord, was challenged, and initially, my lord, interim order was granted. My lord, by virtue of interim order, my lord, there is no break in service, my lord, I have continued in a post. my lords, what has happened during the pendency of the writ petition? My lords, the chief engineer electrical was the, my lord, disciplinary authority who issued a show cause notice to me. And show cause notice, my lord, I have answered to the show cause notice by giving my explanation. My lord, considering the same, my lords, the chief engineer electrical, my lords, has submitted a report before the managing director stating that the complaint is frivolous, therefore we can close the complaint. My lords, the managing director, my lords, have now, my lords, have some instructions with regard to that. My lords, in view of that, my lords, the suspension order has to be quashed, and my lord, the direction has to be issued to the authorities to, my lords, drop the proceedings, since they themselves have dropped the proceedings.
No, what is the second matter?
The first matter is, my lords, also similar. Here is the case, my lords, I am in the
this
care
case,
of
in these two matters, you are questioning only that suspension.
same order, same suspension order only, and both are passed by the managing director himself. In view of the amended rules, my lord, kindly come to, my lords, the amended rules once again. I request, my lords, in a connected matter, first matter.
Yes, you have pointed out that, yes.
No, my lords, in this matter, he is assistant engineer, not the assistant executive engineer. Assistant engineer gave, appointing authority will be separate, and chief appellate authority will be separate. My lord, assistant engineer, kindly come to page 13 of the rules,
Yes.
which I have placed along, my learned friend have placed. Next page itself, my lord, page 13.
I think the last engineer.
Yes, my lord. Assistant engineer electrical. Last in the error point.
Yes, Mr.
That so far as that is in merits are concerned, that regulation 8 which provides that I have to canvass in that. But however, on account of the development in the present case, present situation, now in the second repetition is concerned, that petitioner already retired. That based on that inquiry that he has recommended so far as that there is no allegations with that is in a substantial. That has been accepted by that so far as that is concerned. Now that it has in a disciplinary proceedings has been dropped. Now under those circumstances, does not survive that it is an even disciplinary procedure, that suspension order, because immediately interim order, he has got all that so far as that is concerned. The second petition that in that based on that it can be disposed. In the first petition where that assistant
second will dispose of.
Yes. Please, my lord, with Lord, direction, Lord, one line I request, Lord, because Lord, since he is retired, Lord, the pensionary benefits are, Lord,
That
still
is not the
yet to be.
issue that they will give.
Lord, let there be one line order, my lord.
It is open for him to that it approach and
representation and approach that. Yes.
They will drag on the issue, my lord, because since I'm already retired.
This writ petition in WP 7337 of 24.
Yes, sir.
Yes.
Yes.
Petitioner called in question suspension order dated 5/3/2024 by Annexure D. Learned counsel appearing for the respondent at outset submitted that. Now the departmental inquiry has been concluded.
By dropping the proceedings.
By dropping the proceedings.
Concluded by dropping the proceedings against the petitioner. Later, petitioner has attained superannuation.
31st of May 2024.
Yes, and so on so date. In view of the above, the prior sought in this writ petition will not survive for consideration. Accordingly, writ petition is disposed of.
One line order maybe. For
no, that you give.
Otherwise, not they drag on the issue like.
If they are drag on, then we come. We can't anticipate it that they are going to do it all these things. It is a statutory duty. They have to.
No, yes. No, suspension order has to be quashed because on the ground that it is an incompetent authority has passed an order.
No. I counsel.
Understand.
It is inconsequence because now that the inquiry it's been
dropped, Lord, until and unless Lord, the suspension order has to be quashed, because
no, if you want, that is nothing, Mr. Suspension. That is the procedure which is prescribed for imposing the penalty. Suspension order can be passed. The officer above appointing authority, anybody can be passed. It is not that.
But they cannot. The appellate authority cannot sit as a disciplinary authority.
Appellate authority is
they themselves have.
Appellate authority is for only imposing the penalty. They have prescribed. Appeal is there.
Yes.
Here suspension law is that above that appointing authority has to be kept under suspension. That since it is infructuous, I have not answered that.
Yes. Cannot be.
Other in next petition will answer that.
Let there be a single one line order, Lord, with regard to Lord. They should not delay the process, Lord.
No, Mr. That is not the issue at all. Why should I? If they are not denied.
I understand, Lord. I understand, Lord. Otherwise, Lord, when
if they are denied, denial for that employee, opportunity for the lawyer. That's all. Yes. Yes. Tell. Yes.
In connected matter, Lord.
Connected matter, you are ready?
I am
next
ready.
week, any date. Next week.
Yes.
connected matter leaves this matter on 25th.
Very well.
Much.
That's all. Interim order be continued in.
Interim order granted earlier is extended. to next
Connected disposal.
There was one submission. of
Yes.
Serial number 63, my lord.
230. Yes.